in this trial is represented by Michael Allen, Dave Young, and Angelina Gratiano, who are lawyers with the District Attorney's Office. Would stand and introduce yourselves, please.
Morning. Morning.
I will sometimes refer to the District Attorney as the prosecution or the people. The defendant or accused is Letecia Stauch, and she is represented by Josh Tellini and Will Cook. The charge against the defendant is contained in what is called an information and complaint. An information and complaint simply describes the charge made by the prosecution against the defendant. It is not evidence of anything. In this case, Ms. Stauch is charged with murder in the first degree, child abuse resulting in death, tampering with a deceased human body, and tampering with physical evidence. To these charges, Ms. Stauch has pled not guilty by reason of insanity. Therefore, the prosecution has the burden of proving the charges beyond a reasonable doubt. The jury will decide whether the prosecution has proven beyond a reasonable doubt that the defendant has done the things that are contained in the information and complaint. If I can have all of you stand and raise your right hand, please. Do you and each of you solemnly swear or affirm under penalty of law to answer truthfully the questions asked by the court or counsel concerning your service as a juror in this case?
I never did. Go ahead, Steve.
Thank you. We've already had this issue a little bit, but I want to ask before I go any further, do any of you have any difficulty either hearing or seeing what's going on in the courtroom? Please raise your hand. All right. Looks, hold on, because I have to call you out by number so that I know who I'm talking with. Okay, so first of all, juror number 31 in the sort of, I'm terrible at colors. It's sort of a salmon colored shirt. Yes, that would be you. I say my house is pink. My wife says it's salmon, and I say it's still pink, but it looks like it's sort of a dark salmon colored shirt there. Is that fair? Okay. Are you able to hear me okay? Okay, and then there was a hand in the back, and that would be juror number 65. Yes, sir. Gray hair, long gray hair and beard. Okay, can you hear me now? Okay, so I just need to make sure that I keep the microphone up, and I will apologize in advance to everybody else. Usually not anybody has difficulty hearing me except my children, but I think that's more by choice because I have a really loud voice, but I'll try and keep it using the microphone. Is this better when I use the microphone? Okay. All right. I'll just have to watch that more closely. In this case, 12 jurors and 6 alternates will be chosen. They will consider all of the evidence produced during the trial. The jurors will determine the facts based on this evidence. The attorneys anticipate this case will take 6 weeks for trial. This does not include deliberations or jury selection. We hope to start the presentation of evidence in this case on April 3 of 2023. So that would mean finishing evidence sometime mid to late May. I understand the burden that such a lengthy trial places on people. I previously presided over one case that took about 18 weeks from start to finish. So I get it. I understand the commitment here. Our trial days will generally be from 9 to 5, Monday, Tuesday, Wednesday, and Friday. There will not be any trial on Thursdays as I have other docket matters that I have to attend to on those days. You will be able to go home to your families each day, and though you will not be able to discuss anything about this case with them, you will be able to talk to them about anything else. You'll be able to go on about your normal daily activities. You just can't discuss anything about this case with anyone. Knowing this time commitment, is there anyone who believes they would suffer an undue or extreme hardship if required to serve for this trial? Please raise your hand. And we're going to start in sections. So I'm going to start over here first. So let's see. Juror number 5 with the gray hair and a dark shirt. Yes, ma'am. Okay. You actually are juror number 5 because your juror number may have been 1786, but what we're referring to you hereby is your seat number. And before I forget, and before we take any break or get any further, please remember where you are seated, because when we take a break, you got to come back and sit in the same seat. We honor the 3rd grade seating chart here, so it's really important that you be in the same seat. So juror number 5, you had your hand up. What's going on?
large family.
When is that? Okay, and juror number 7. Yes, ma'am. That's you. Yep.
I have 2 children at home. So
How old are they? And middle schoolers, junior high? Okay. So it sounds like during the large portion of the day, they would be at school. When do they get out of school? And would there be anybody that can pick them up, get them home? Do they take a bus? What do they do?
I'm a high school Spanish teacher.
Okay, so it's, so you have 2 children that you're the caretaker for, but those are at school during the day. They have activities after school, but you're also a Spanish teacher. Do I have that right? Okay, and juror number 8.
It's about to be placing.
When is that? Uh, Okay. And where is it that you would need to go? And if he's placed into the nursing home, what would be your role in that? But the house that he's moving out of, I take it then he must not be living with someone. He's living in his, I got it. Okay. All right. And juror number, I thought 9, number 10? Yes, ma'am.
I have ongoing physical ability and therapist has recommended just that I have diagnostics done. I go.
Okay. In the front row here, juror 11. Yes, ma'am.
I am the sole provider for myself financially. If you
What kind of work do you do, ma'am?
service at Lowe's,
Okay. And is that an hourly or a salary? Okay. And juror 12. Yes, ma'am.
my daughter's getting married next week
Congratulations.
in Arizona.
And when exactly is it?
She's getting married Friday, and we weren't coming back to town till this,
Till,
dropping my husband off
got it.
Albuquerque for work.
Anyone else in the front row? Let's see. Juror 15. Yes, ma'am.
Played CPA. Need I say more? It's a month.
This is, there's something coming up soon.
Yeah, it's crazy.
I'll see if I can get the government to change those deadlines.
That would be awesome.
I'm sure they'll be interested in my input. Anyone else in the front row over here? No? Okay. Juror number 3, yes, sir?
I can't speak too much English and I can understand too a lot.
Okay. And what kind of work do you do, sir? Okay. All right. And then let's see, we were at juror 17. Did you have your hand up, ma'am? No, she's 15. Six. No? Okay. Juror number 18? Yes, ma'am.
I have some health issues and I cannot guarantee you I would be here every single day.
Okay, can you,
Guarantee you I could sit in the courtroom without having to be excused without waiting for breaks.
well, typically what would happen is that we will have a break in the morning, we'll have a lunch break, we'll have a break in the afternoon. If people need to stand, stretch, those sorts of things, they can do that. Okay,
Since I did just issues.
okay.
And I have no control.
Okay. Anyone else in the front row? Juror 20?
I am a full-time 5th grade homeroom teacher. I sometimes been here at school year and I'm also a full-time night class.
Let's back up for a moment. As I understand it, you're a full-time 5th grade teacher. And you're going to nursing school or you teach nursing school?
My classes are hours.
Okay, is there anybody else that I missed? Juror number 5?
Just the issues.
Okay. Okay. 5. Right, and then in the this back section over here, front row, juror number 23. That would be you, yes, sir. Perfect. When is that? Of April? April 1? Oh, 13th, okay. Okay. All right, others in that first row? Let's see, 23, 20, juror 25? Yes, ma'am. Okay. Juror number 26?
I go to school and I have classes on Tuesdays and Thursdays. And I have oncology appointments in May.
Tell me about the classes on Tuesdays and Thursdays.
It is, economics. And I have,
Ethics.
So you have more than one class on Tuesdays? 3 classes, okay. Okay, and juror 27? Yes, ma'am.
I don't feel I could be impartial to this.
Okay, I'm not asking that. I will ask that later. I'm not asking that now.
Appointment on the 24th and surgery on.
Okay, we won't even be starting trial until after that. So,
On for the month of April.
okay. Anything else that you want to tell me?
That's about it. Thank you.
Okay. All right, and in the second row, that would be juror 36. Yes, ma'am. Yep.
Your Honor, I'm in the middle of a, our friend here 3 times a week. So,
Let,
last half of my treatment. That long with it. Not the most comfortable, secondary to that, I'm on 2-4 Friday. Been gone for that amount of time. Other 2 things I could probably work. Back and sitting.
okay, so I just wanted to make sure that I understand what you had told me because it sounded, it wasn't clear to me whether you were a patient or whether you were the doctor. You're the patient. Okay. Okay, just wanted to make sure. All right. Also in the second row, nobody else till the end, 41, juror 41.
I own a small business with 4 employees. On call for the kid. I'm the only one that can come. I also have a receptionist to.
Okay. And
I have vacations.
okay, what kind of business is it?
Salon.
Okay, right. Okay, and back row. Juror 50? Yes, sir. Okay, thank you. Anyone else in that back row? Let's see, 52? Okay. If you need to stand or stretch or anything while we're doing that, or while we're doing this, feel free to do that. It's okay to do that. And will that help? Okay. It's not scheduled yet. You just, okay. All right. Got it. Anyone else in that back row? Let's see. Be juror 54. Yes, sir.
Your Honor, loss of wages, I, primary source of income for my wife, so my loss of wages. I didn't.
Okay. Anyone else in that row? No. All right. This section here, first row, juror number 28. Yes, sir.
I'm the only, by myself, and, family trip and for
Okay. Next in this row will be juror 30.
Thing one, I've got a non-refundable vacation mid-April. Number two, I manage a group of consultants. 12 of them, and once would be devastating.
Okay. Next, juror 31. Yes, sir.
I attend my mother on a daily basis. Her meals ready for the evening. Grocery shop for her. What her other needs are, doctor, dentist appointment.
Um, Now, as far as tending your mother, you would still be able to do that. It would just have to be outside of court hours, like before 9 o'clock in the morning, well, before 8:30 in the morning and after 5. Okay.
Ready for an evening meal. I'm being taken care of. I've got a sister, but they both, one is just had an amputee.
Okay. All right. And juror 31, or I'm sorry, juror 32. Yes.
Urinary problem.
Okay. Anyone else in the front row? Second row. Let's see, we'll start over here because it's a little bit easier. Juror 48 on the end there. All right. And juror number 46.
Children, 2 and 3, or I'm sorry, 3 and 5. One's in preschool, half day preschools. Oh, she also has.
Anyone else in that row? Juror 45. And how old is your mother? Anyone else in that second? Juror 44.
Having company. Also,
Anyone else in that row? On the end there, juror 42. When was the TBI?
Been going on for the past 20 years.
Okay. Okay. All right. Thank you. All right, and in the third row, juror 56 on this end. When are you doing that? This month, okay. Okay, thank you. Juror 57.
Yes, I'm the sole caregiver for my 84-year-old father. Need to be able to transport him to appointments and stuff. During the day and
All right. Anyone else? Let's see. The end. Juror 61. Yes, ma'am.
Our house in Florida, April 11th.
Okay. T- um, Tell me that again, because you're
Rain on the
okay. That one. Okay, I didn't catch the first part of the date. That was all right. Okay. Juror 62. All right, and then the next row behind that, juror 3. This is going to be the bad part here because now I'm in the area with the gentleman that can't hear me unless I speak into the microphone. Juror 63. Yes, on the end. All right. Juror 64. Juror 65.
Off the sale. I gotta work, make sure I keep my bill and stuff paid on the house.
Were there other hands back there? Okay, juror, hold on just a minute. Um, Juror 66. Yes, that would be you.
I don't think that's 66.
It is, and I just noticed that it's juror 67. Right. Juror 68. And juror 69. All right, in the back row. Juror 70. That's on this far end over here. Yes, ma'am. Juror 71. Okay. Juror 72, did you have your hand up? Yes, ma'am. Okay, where do you go to school? Okay, I've already had some UCCS students in through here, so I understand what the situation is. In addition, well, I can provide a letter to you for your professor to let them know. The other thing that I want to ask is, because some of the UCCS students said that they would potentially be able to, I think some of the classes were recorded and they said they could catch up with them after we were done for the day with trial. Is that a possibility? Okay. All right. Juror 73, did you have your hand up, sir? No, the gray-haired gentleman. Did you have your hand up, sir? No. Okay. Juror 74, did you have your hand up? No. Juror 75. Okay. I need to go through some reasons why a person may be disqualified from jury service. So if any of these reasons apply to you, please raise your hand. Are any of you related to the defendant or any of the attorneys? Please raise your hand. No response. Do any of you have a relationship of guardian and ward, employer and employee, landlord and tenant, debtor and creditor, or principal and agent to, or are you a member of the household of, or a partner in business with, or surety on any bond or obligation for the defendant? Essentially, that's a long lawyer question asking whether or not you have a particular relationship with the defendant. Does she rent from you? Do you rent from her? Do you employ her? Does she employ you? Any of those kinds of things. Anyone think they're in that category? No response. Are you now or have you ever been a party in a civil lawsuit involving the defendant or have complained against or been accused by him, by her in a criminal prosecution? Anyone think they're in that category? No response. Were any of you a witness to any matter related to the crime or its prosecution? Does anyone here think that they are a potential witness in this case? No response. Do any of you have a personal or financial interest in the outcome of this case? No response. Do any of you have any feelings or a bias for or against the defendant or the prosecution? Please raise your hand. Juror 20? Yes, ma'am. Okay. I want to make sure that I heard, because you're soft spoken. I had a little bit of a hard time. You teach Gannon Stauch's sibling currently. Okay. And given that, and I don't want you to tell me any specifics. You know what? I think this is just, yeah. Let's just, what I'm going to do is I'm going to excuse you based on the personal contact. And I think that's enough. So we'll just excuse you at this point in time. And juror number 2. Yes, sir.
I think
I just have a bias from reading the news over the last couple of years and following the case.
Okay, and I'll get to that in more detail, but I appreciate you bringing it up now because that is going to be a question that I'm going to ask about bias as a result of publicity because this case has received some. So I will be asking those questions separately, but thank you for mentioning it now. Juror number 3, did you have your hand up, sir?
I had an appointment tomorrow in Denver in the hospital.
Okay. So, and I was going to check on you in just a moment to see how you were understanding things that were going on. And you said that you had, how have you been doing in understanding us so far? I'm sorry? Okay. All right. Are any of you an employee of any public law enforcement agency or the public defender's office? Please raise your hand. And I have juror number 22. Yes, sir. What kind of work do you do there? Are you a certified peace officer? But, okay, so you're a civilian, but your paycheck comes from CSPD. Okay. Okay. And is that, I'm just trying to understand the relationship. Is that a full-time spot at CSPD? And the records that you work with, are those arrest records or personnel records or what? Okay. Anyone else? Juror number 9? Yes, sir. For the State Department.
State of Colorado.
Right, right. Yeah, my question was not very artfully phrased. So it's the state of Colorado. Anyone else? All right. Please raise your hand if you are not a citizen of the United States, are not at least 18 years old, nor a resident of this county. Anyone think they fit in that category? Response. Please raise your hand if you are unable to read, speak, or understand the English language. And juror number 3, you said that you have some language difficulty. Are you able to read the English language?
Read and speak too sometimes.
Okay. Please raise your hand if you are incapable due to physical or mental limitations to render satisfactory jury service. Anyone think they're in that category? Let's see, where are we at here? Juror 52? Yes, juror 52. Oh, right. Okay. Anything that you've not raised before juror 42? Anything that you've not raised before? No, 42 is this gentleman over here. You're 42, yes. That's okay. Okay. So, and I thought there were some hands over here. No? Any other hands aside from those two? Juror 25. Well, and if you're selected to serve as a juror here, you won't be able to do that. So my question is, do you have a physical or mental limitation? Okay. Anyone else aside from the people that I've talked with? No? All right. Please raise your hand if you have the sole responsibility for the daily care of a permanently disabled person living in your household, such that your service would create a substantial risk of injury to the health of that disabled person. Anyone think they're in that category? Please raise your hand if you've served for 5 days or more as a trial or grand juror in any state or federal court within the past 12 months. Anyone think they're in that category? Juror 56. Yes. When did you do that? The beginning of 2022. Okay. All right. Thank you. Anyone else? All right. No further response. Council approach, please. All right, ladies and gentlemen, what we're going to do is take about, sorry, Beck. Ladies and gentlemen, what we're going to do is take about a 15-minute recess. Here's what you can expect will occur. If I can have everyone back in the hallway ready to go at 10 after 10, then what's going to happen is when you come back, there's some jurors that I will excuse. Other jurors will remain here and we will have further instruction and further questioning for those jurors. And we will proceed from 10 after 10 until about noon or so. So at this point in time, I can have all the jurors exit the courtroom and we will see you back at 10 after 10. All rise for the jury, please.
You can leave your backpacks and coats if
You can leave anything here that you want to because you'll be coming back in.
come back.
Talking to myself. Right?
Thank you. You may all be seated. Were you, oh, I didn't know if you were wanting to make a record about something as you were standing up
I
there.
was just playing with the fancy light.
Got it, okay. All right.
I didn't spill my coffee.
Good job. What I thought. Bill's gonna go visit.
Purdue golf course. Do you still play a lot of golf?
Define a lot.
The answer is yes.
In the summertime, do you play once a week?
Sometimes.
Play a lot.
I'm not playing a lot right now.
With the one on Templeton game?
Didn't think of it.
No. I like playing around different courses, you know.
Flat or something?
Yeah, he lives right up.
Apparently Judge, our mics are picking up stuff over here today. I just got a text.
Thank you, because they're off. So apparently turning them off is not the issue.
Although, what happened yesterday was working fine.
Yeah. No, they are turned off, so yeah, you can put it back on the floor. Oh, you did. Okay. You can put the microphones back on the floor if you want to. And it may be that we just, because we're streaming it the way that we are, that we're just going to have to do it without microphones on the council table and deal with it, just like we used to. But we'll have everybody up front here and the jury, so they ought to be able to hear everything fine. So that ought to be fine.
Correct.
Casual look today, huh?
Yeah.
Good. Good show, looking glassy, lucky, right? Switch it to me anyway. Well, I bet you if you tighten up the bottom. Just one down and try to get that more out.
I don't want to lean back. I want it.
Yeah, no,
more
it's all right.
like-
It's fine. Worst comes to worst, we'll start using the microphone, but I don't.
No, we don't have. She's not doing it. This is. That's both the kids. No, I'm an adult.
Oh, you're gonna watch me now.
So I hang out with Will, I think he was more mature, responsible.
I like that approach, that's good.
Rodney Dangerfield in old school. Laura Alexander hang out with better people.
Says that Parker working really hard in the office.
We do.
Just makes it hard to.
Probably half the everything.
Let's begin.
I think we're gonna need that actually, when we start doing that.
Hard here.
Yeah.
No.
I don't need to make a record. I'm just need to stand up some.
I have two issues that I want to discuss with the juror, or with the attorneys. The first one is juror 16, who I do not have as a person I'm going to excuse at this point in time, says that, or she informed my clerk that she's asking for another hearing device. She says she can hear me fine when I'm using the microphone, but could not hear hardly anything that was being said in the back of the courtroom. So I don't know if it's going to be an issue at the time of trial. It certainly would be an issue for the rest of voir dire. So I don't know what you want to do about that. Prosecution.
So what I've noticed, Judge, is that she's distracting the people that are near her too, because she keeps asking them questions. Because she can't hear.
Okay.
And so I think she's exhibiting
No,
particular difficulty, so I'd be fine if you want to release her.
okay.
I would concur.
Okay. I did not notice that because I was watching what was going on in the section
So
that I was
that's
at.
16.
Yes. And then the other issue is with respect to juror 22, Juror 9, I think, is a clear excusal. Juror 22, I think probably is your position prosecution. Based on his employee, he's the city employee that works for CSPD, although he's a civilian.
Yeah, so he is not a law enforcement officer. I don't think by statute that he's an automatic release.
Mr. Defense?
He's a compensated employee of a law enforcement agency.
Yeah, it's, you know what? I think I'm going to leave him on for just now. Actually, I've got time. I'm going to run back to I'll be back in just a minute.
I mean, the statute is compensated employee.
Well,
So it's just like, I mean, if there were a secretary of the public defender's office, it would be off.
right. And I know that there's some cases on it, but I don't have my laptop.
And the cases generally go for like people who work for other things, like if you're in the military, but you're military police, or if you're working for something, and you're a law enforcement agent in that company.
Hey,
That's not necessarily primarily.
Gary, can you grab my laptop off of my desk? You'll have to unplug it and just bring it down. Thank you. I'm tending to side with the defense here, but I want to take a look at some of the research that I have on my laptop. So I will probably keep him here until I take a look at that, and then we can raise it again. But I think Mr. Tellini's right. So before we bring the jurors in, these are the jurors that I intend to excuse. We already excused juror number 1 and juror 20.
And 16.
No, not yet.
Well, will be, yeah.
Will be. So these are the ones that I intend to excuse in addition to those. Juror 3, juror 5, 7, 8, 10. I can tell that Mr. Cook is following along. 11, 12, 13, 15, 18 has already been excused. 23, 25, 26, 27. Thank you. 28, 30, 31, 32, 41, 42, 44, 45, 46, 48, 50, 52, 54, 56, 57, 61, 62, 63, 64, 65, 67, 68, 69, 70, 71, 72, and 75. Yep. It is. And we're just going to excuse ourselves. We're done. Yeah. Oh, I did not. I did not. So we're going to excuse juror 16 as well. Sorry about that. And juror number 9.
9.
Yeah, he's the Homeland employee.
I must have missed something on 13.
13, I did excuse. 13 was, I should not have excused 13.
Yeah, that's
No,
right.
13 stays in, I'm sorry. 13 is not excused. 11, 12, 15, it should be 11, 12, 15,
Yes, okay.
18, 15, 16, and 18.
Oh, 16?
16 is the
Oh, yes,
hearing
16.
problem.
Yeah, yeah.
Are you researching 22, Your Honor? Gonna let me
Yes,
go with
I
the
am.
match, or-
I am, and yeah, because I don't think he has to be a sworn officer.
I mean, the statute, I'm looking at 1610-103.
Hold on. Go ahead.
1610-103 subsection K, the juror is a compensated employee of a public law enforcement agency or a public defender's office.
Right. And there was a case that I was looking for that I have in my research. Let me see if I can find it. But I think that was sort of the issue is the person was not a sworn peace officer, but was employed by, I thought it was a sheriff's office, if I remember the case right. We can go ahead and bring the jurors in.
I thought we were gonna discuss these.
You were, yeah, that go there, 1, 2, 3 over.
Just stay right here until we can put the chairs back.
There's one more to go down the road.
Yeah, I have to stay. I just didn't want to move the chairs if there were still people coming. Everything in a while. Isn't really weird.
We'll do a little.
Okay. It doesn't work for you. Number 7, 8, 9, 10, 11, 12, 15. 18. You guys are in the wrong seats, right?
No, I'm in the right seat. 20 is gone.
Number 20. Yeah, that's what.
Wait a minute.
Okay. Threw me off there. I was like, wait a minute, wait a minute. Okay, all right.
So 18.
So 18, yes, you're in the right spot. I see what happened. Just need to share, so that's okay. 23, gentleman here. 25 in the sweatshirt. 26, hidden buffs, lots.
Hidden buffs, yeah.
Okay. 27. 28. 30, 31, 32. Starting again over here, 41. 42, you'll be excused. 44. 45. 46. 48. 50, second gentleman, or the gentleman, yep, you would be 50. 52. 54. And 6. 57. 61 and 62. In this row, 63. 65. 67. 68, 69. In the back row, just 70, 70, 71, 72, 75. So the people that I've excused, you are excused with the thanks to the court. You can go ahead and leave the courthouse.
Thank you.
Back at the jury assembly.
I know.
Okay.
Oh, you don't get.
Thank you.
All right. Okay. Now, you do have to remember where you're sitting, but especially those people in that front row there, if you want to spread out a little bit more, it's okay if you want to do that. You do have to, it is still the third grade C. It's okay. You know, togetherness is a good thing. It's all right. But if you want to have a little bit more room and spread out a little bit more, that's okay too. All right. Oh, I see what you did there. I was going, wait, who's that? And okay, I see what you did. Nope, that's okay. It's all good. All right. In juror 22, I want to ask you a little bit more about your job. Because you're a civilian, but you're employed by the city of Colorado Springs, right? So you're not employed by the Colorado Springs Police Department. You are, but you work at the police department.
I am employed by Colorado Springs Police Department as a city employee. work for the city, but I work in. Yes, we do.
Okay, and that's what I'm trying to understand, because, how it's the city that pays you, right?
Correct.
So it's the city that pays you as a city employee, not the Colorado Springs Police Department that pays you.
I'm employed by the police department.
Who do you report to? Who do you report to?
I work out at POC.
When something goes wrong or you have a supervisor, do you have a supervisor?
Goes out for chain of command. Yes, we do.
Okay, that's what I wanted to know. All right, I'm going to excuse you as well, sir.
Thank you.
Okay. All right. At this point in time, I'm going to give the attorneys an opportunity to give you sort of a 2-minute mini opening statement, and it's really just an opportunity for the attorneys to tell you what they think the issues in this case are. It's not necessarily what you'll find them to be if you were selected to serve as jurors. So with that, prosecution.
Thank you, Your Honor. Good morning again, everybody. This case is about two people. One of those people is Gannon Stauch. He was an 11-year-old boy who lived with the defendant and his father, Al Stauch, in the Lorson Ranch neighborhood, which is the southeast part of the city near the Colorado Springs Airport. The other person involved in this case is the defendant. You'll hear evidence that Gannon was a fighter from the very beginning. He was born premature, weighed 1 pound 6 ounces. He fought to live, and he fought in the last moments of his life. The evidence will show that he was stabbed 18 times, including defensive wounds to his hands, arms, his back, his armpit, that he was hit with some blunt object that caused his skull to fracture. You will also hear that he was shot 1 time in the jaw. You will hear that he died in his bedroom, a safe place for most 11-year-old boys. You will hear then that he was stuffed into a suitcase, loaded into the back of a van, and driven from Colorado Springs to Pensacola, Florida, by this defendant. You will hear that she then threw him over the edge of a bridge and left him there. His body, his mangled body, was later recovered, closing the circle on what happened to Gannon Stauch. At the end of the presentation of evidence, we're going to come before you again, if you end up on this jury. And we're going to ask you to convict, find the defendant guilty of murder of Gannon Stauch, a little boy who fought to live and fought before he died, and fought this defendant. Thank you.
Right. Thank you. Before we start the defense argument, we're going to make a change here. No, it's the one in the podium.
This one right here.
Pull it out and leave it out. Otherwise, it's causing echoing. So it was
That was my plan, Judge.
okay. All right, Mr. Cook.
Good morning, ladies and gentlemen. My name is Will Cook. I represent this lady
Yeah, that's a lot better.
at the table in the blue shirt, Letecia Stauch. Ms. Stauch has been charged with committing first-degree murder against Gannon. We all know why we're here. You've known it since you filled out the jury questionnaires this morning, and it gave a summary of what's going on. A lot of what Mr. Allen just said is true. You're going to hear circumstantial evidence that Gannon was killed, he was stabbed, he was shot, his skull was fractured. He was taken to Florida, Pensacola area, his body in a suitcase, and he was thrown off an overpass of a highway. His body in that suitcase remained in the Florida heat for 6 weeks. If you're on this jury, you're gonna see photos. of The autopsy and this body. You're gonna be horrified, disgusted, destroyed, and tormented. If you serve on this jury. And we're not saying that this happened and she did it. But you're also going to hear some more information that Mr. Allen didn't discuss. You're going to hear, and it was mentioned in the jury questionnaires, about insanity. You're going to hear about dissociative identity disorder. An acronym is DID, dissociative identity disorder. Used to be called multiple personality disorder. You're going to hear from Dr. Dorothy Lewis, a doctor from Yale University, who's going to
Wrap up your comments, please.
testify that Ms. Stauch, at the time of this crime, suffered from DID. And that in fact, she was legally insane at the time of this crime. After all this information, weeks down the road, we're going to come and ask you to find our client not guilty by reason of insanity.
Thank you. I want to read some of the instructions that you will receive later because I think that they will help guide our discussion going forward. Every person charged with a crime is presumed innocent. This presumption of innocence remains with the defendant throughout the trial and should be given effect by you unless, after considering all the evidence, you are then convinced that the defendant is guilty beyond a reasonable doubt. The burden of proof is upon the prosecution to prove to the satisfaction of the jury beyond a reasonable doubt the existence of all of the elements necessary to constitute the crime charged. Reasonable doubt means a doubt based upon reason and common sense, which arises from a fair and rational consideration of all of the evidence or lack of evidence in the case. It is a doubt which is not a vague, speculative, or imaginary doubt, but such a doubt as would cause reasonable people to hesitate to act in matters of importance to themselves. If you find from the evidence that the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, you will find the defendant not guilty. A few minutes ago, you heard me tell you that the defendant was presumed to be innocent. This means that if I were to tell you, or if I were to give you a verdict form right now and ask you to fill it out, the law would require that you find the defendant not guilty. That's because you've not heard any evidence in this case and the defendant is presumed innocent. Evidence in this case would be exhibits. It would be somebody who comes forward, raises their hand, swears to tell the truth, takes the witness stand, and tells you what they have to say. Nothing that the attorneys say ever is evidence. They don't take any oath to tell you the truth. They are here to present evidence. They are advocates. They are paid advocates for the position that they want you to believe. So nothing that you've heard yet is evidence. In addition, someone may ask you whether or not you think the defendant has done something wrong or else she wouldn't be here. However, that's an improper question. We don't just randomly select people from the street to suddenly appear in the courtroom as a defendant in a case. Obviously, there is a process in place which resulted in the filing of charges against this defendant. However, the charges against this defendant are not evidence either. The charges against the defendant are just accusations. The fact that the defendant has been accused is not evidence that the defendant committed any crime. The defendant is presumed to be innocent, and until the district attorney presents sufficient evidence to overcome that presumption beyond a reasonable doubt, you must continue to presume the defendant is innocent. Stated differently, unless and until the prosecution presents sufficient evidence to overcome the presumption of innocence beyond a reasonable doubt, Ms. Stauch's guilt has not been proven. That's what the presumption of innocence means. You may also find it useful to think of the charges in this case as similar to a recipe from a cookbook. That's because when you see the charges, they have certain things in them that the prosecution must prove beyond a reasonable doubt. For instance, suppose that you wanted to have a Denver omelet, you took some eggs, you scrambled them up, you added some ham, you added some Swiss cheese, and you added some mushrooms. In that event, you might have a really nice ham and cheese omelet, but you wouldn't have a Denver omelet. If the prosecution charges the defendant with a Denver omelet, that's what they have to prove. No substitutions on the menu are allowed, and proving something else doesn't necessarily prove the elements of the crime with which she has been charged. The prosecution has to prove beyond a reasonable doubt what it has charged and not something else. I also want to talk for a moment about the defendant's right to remain silent. Someone may ask you whether or not you would need to hear from both sides in order to be fair. Everybody wants to be fair, right? And you can only do that if you hear both sides, right? I mean, for those of us who are parents, we look and something happens with our children, we go in there and say, okay, what happened? Okay, what happened? Well, that's not the process that we follow in a court of law. This isn't the Maury Povich or Jerry Springer show. The government brought these charges against an individual. Because of that, the government has the burden of proving beyond a reasonable doubt every element of the charges that it brought. Stated differently, the defendant does not have to present any evidence or any testimony. In fact, defense counsel, I suspect they're not, but defense counsel could choose to do nothing or take a nap at counsel table, and that would not change the prosecution's obligation to prove every element of the charges beyond a reasonable doubt. In addition, every defendant has a constitutional right not to testify. The decision not to testify cannot be used as an inference of guilt and cannot prejudice the defendant. That's because it is not evidence, does not prove anything, and cannot be considered for any purpose. Now, sometimes the attorneys will ask a question of all of you designed to elicit a response from you such as, well, I know that if I were accused of something, I would take the stand and I would talk until everybody understood my side of the story. As I indicated earlier, however, that's a trick question because that's not the process we follow in a court proceeding. In any event, does anyone here know what the number one fear in the population is? It's greater than the fear of death and greater than the fear of running into a rattlesnake on a hiking trail. It's the fear of public speaking. So naturally, the first thing that we do is bring in as many strangers as we can pack into a courtroom and have them start talking in front of a bunch of other people. And I want you to think about that process for a moment. When you were asked a question, were you nervous? Or were you going, if I sit here, maybe they won't call on me? And you weren't sitting there in the witness stand, subjected to questioning by attorneys on maybe very difficult topics with a whole bunch of people just staring at you and realizing that they were going to decide what the facts in the case were. The bottom line is that it is possible that the defendant won't testify. It's possible that the defendant will testify. But regardless of who testifies or who doesn't testify, and regardless of whether you hear something more from someone or not, the real question at the end of the day is always the same. And that is based on the evidence that has been presented, whatever that evidence is. Has the prosecution proven beyond a reasonable doubt that the defendant is guilty of the crime charged? Is there anyone here who thinks that they would have to hear from the defendant before they could decide the matters in this case? Please raise your hand. No response. You've heard us talk a little bit about what this case is about. You heard it or you saw it in the questionnaire. You heard what the attorneys had to say. And I do want to ask Have any of you heard anything about this case from any source, including friends, family, the news, or other media, or the internet? Please raise your hand. A lot, almost a lot. Okay. In this case, you will be asked to render a decision based on the evidence presented in this courtroom and the instructions that I give you. Even if you have heard or read something in the media or heard something from your friends, the real question is whether or not you can put that aside and decide this case based on the evidence you hear in this courtroom. For those of you who raised your hand and said that you had heard something or seen something in the news, on the media, from a friend, anything like that, is there anyone who thinks that they cannot put that aside and decide the issues in this case based on the evidence they hear in the courtroom? All right, start over here. Juror number 2. Yes, sir.
I just feel I have a strong bias and it's going to be difficult to set that aside.
Okay. And is that based on, I'm just trying to figure out the source. Is that based on media? Is it based on conversations you've had with people? Media. Okay.
And life experience.
Okay. Now, in this case, you heard me tell you about nothing that the attorneys say is evidence, and the only evidence comes from somebody who sits on the witness stand. I can tell you that, at least in this case, nothing that the media has said is evidence either. They may have reported certain things. They may have got it right. They may have got it wrong. The question here is whether or not you think you can put aside what you've read and decide this case based on what you hear from the witness stand.
I think it's possible, but I think I have a bias.
Okay. Did you have your hand up, sir? Okay. And you are juror number 6. Yes, sir.
Yes, I have seen in the media the arrest warrant was posted online. It had many photos that coincide with the description that we were given by the DA. I understand none of this is evidence. Cast that aside and be as unbiased as possible, but I'm afraid that I may not.
Okay. In the front? No? Over here in this group. I'm trying to figure out, I think that you're probably just resting your hand, juror 35, just making sure. It's okay. You can put it back up. It's all good. Just making sure. All right. Juror 55. And over in this section. All right, let's see. 1, 2, 3. Juror 59. Yes, ma'am. Okay. And juror number 60, did you? Yes, ma'am. Okay. Can I ask the the jurors to look around the courtroom? And the question that I have is, do any of the potential jurors know each other? All right, no response. This question is separate from the media, but is there anything about the nature of this case which would in and of itself influence any of you at arriving at a verdict? And in the back, juror 73.
I've heard everything on TV.
No, I appreciate that. And, I've done this for a long while and I've presided over a lot of different cases and including child abuse and sex assault on children and those sorts of things. And no one ever comes in and thinks that this is a good thing, right? They always, this is a terrible crime. When you bring them in for a sex assault, they say, well, it's a terrible crime. It's a crime that involves a young victim. And there's not anybody that's going to argue that somehow that's justified, such as, a self-defense in a shooting or something like that. But we still have a process that we have to work through, and it sounds as though you have some feelings, but you think that you could follow the law in this case and do the best that you could regarding that. And you think that you would, well, let me ask it this way. Do you believe that you would be able to follow the law, give the defendant a fair trial? All right. And juror number 74, did you have your hand up? No. Okay. I just wanted to make sure. I wasn't sure if you did or not. Is there, juror 24? Yes, ma'am.
I am 15 weeks pregnant, so I don't know. I'm pretty like emotionally sound as of now, but maybe upcoming emotions.
Okay. Well, assuming that it stays that way, do you think that there's anything about this case which would in and of itself cause you difficulty serving as a juror?
I know.
Okay. All right. Anyone, juror 36. Yes, ma'am.
I put on my case that I do have a 17-year concept of any being done to a child up the process, and I would want to make sure it's fair, because as you explained, words like that doesn't always lend itself to life.
Right.
Story.
No, I appreciate that. We all bring in our own set of circumstances with us when we come in. We all have our own past and our own experiences. And the law, you're not required to set any of that aside, frankly. That would be A, impossible, and B, sort of kind of ridiculous. I mean, I don't think we're going to get any kind of fairness in the law if that's what we require is just a bunch of robots to come in. But what you can't do is allow your emotions to overcome what the law and the facts show. And by that, I mean, years and years and years ago, you would have a mob that would say, this is what we need to do, and this is what we need to do, and we need to take retribution, and there's no due process, there's no following of rights, and that's not what this process is about. So what we do require, and you actually get an instruction that says you shall not be influenced by sympathy, bias, or prejudice for or against any party. And you have to decide the case based on the facts and based on the law that I give. Do you think that you can do that?
Can I tell you 100%?
Okay, fair enough. Thank you. Anyone, juror 34. Yes, sir.
Yes, sir. I share the same, sympathy with them. I have a problem with it. In my own mind, I'm skeptical. Far along in the process, but I just wanted to share that.
No, I appreciate that. And for a lot of people, I mean, I had this yesterday, actually. A number of people are going, I have a problem with the insanity part. And it gets really to the foundational bedrock of the judicial system, because essentially what the judicial system is intended to do, I don't know if there's any, are there any people with psychology backgrounds in here? Okay, have a couple. What it is intended to do is modify behavior. Okay, I mean, and the idea is if you're doing something wrong, and we're not going to get into morality and stuff like that, but the issue is whether or not there's something that's against a statute, so it's illegal. Let's put it that way. If you're doing something illegal and we don't want you to be doing that, there is a punishment that goes along with that. And the idea, hopefully, is that somebody else perhaps sees that, you see that, and know not to do that. So you get a ticket and you know that you're not supposed to do 70 miles an hour in a 55. So the idea is, I don't want to pay a ticket again. I don't want to get a ticket. I don't want to have to pay that fine. I don't want to get the points. I don't want to have to deal with the DMV. I don't want to go to the administrative hearings. This is going to be a huge hassle. So the idea is that there's a lot of bad potential that comes out. So we say, I'm just going to drive 55. That's just easier. Okay. So the idea behind criminal law is to modify behavior. There is a penalty that is put in there, or a punishment that is put in there so that behavior will change from the person who's doing it or may do it. Because other people, and it works as a deterrence for other people, because other people see, well, my friend got a ticket and he went through all of this. I sure don't want that to happen to me. So there's a deterrence for the population at large. There's a deterrence for the individual. And that sort of makes sense, right? I mean, we're going, yeah, we want people to behave in a particular fashion for our society to function. But the law also recognizes that in some circumstances, there may be a person who cannot conform their conduct, or does not understand right from wrong, or does not understand the mental process that is necessary for the action to occur. And when we have those types of cases, the law recognizes that those people they're not in the same category as somebody who can modify their conduct. And that's why the insanity plea is allowed, because there are some circumstances when everybody would look at it and say, yeah, we understand that this happened, but there's something that's going on such that they ought not be legally responsible as somebody else. Does that make sense to you? Okay. Is there anyone else who has any questions, comments, or thoughts about that? No response. In addition, in this case, this is not a death penalty case. You're not going to be deciding the punishment in this case. If any punishment as a result of any verdict that is returned, whether it be guilty to the charges, not guilty by reason of insanity to the charges, that would be decided by me. So there's not anything that you have to decide there. Essentially, what the jurors have to do here is make a determination based on the facts and the evidence that's presented, what happened, and what was the mental state of the defendant at the time. Remember when I told you that this is kind of like a cookbook? When you see it, you will see that the instruction for the charges, they always start out with in the state of Colorado on the date or place, and then they give the date of the offense. And then there's a number of other elements. The very last element will be, and let's see, I can't remember whether it's phrased in was she sane at the time, or did the prosecution prove that she was sane at the time or not insane? I can't remember how it's phrased. But you'll have all of those elements. And what you have to decide is whether or not the prosecution has proven each and every one of those elements beyond a reasonable doubt. Is there anyone who thinks that they cannot do that? No response. Oh, in the back. Thank you, sir. Juror 59. Yes, ma'am. Okay. And juror 60. Okay.
That was
59 and 60. Yes. All right. There's one other thing that I wanted to talk about very briefly. Council approach, please. All right, ladies and gentlemen, what I'm going to do at this point in time is I'm going to excuse jurors 59 and 60. And then, so you can go ahead and go. What we're going to do is we're going to hand out a list of witnesses. It's a number of pages. I want you to look at all of the witnesses. And the question that I have for everybody at the end is, do any of you know any of the potential witnesses in this case? The whole thing. It's because some of them are what we refer to as lay witnesses. That is maybe an eyewitness that saw something. They don't have a particular expertise. And then there are others who are experts. So yeah, you do need to look at all of them. All right, looks like most everybody is done. Is there anyone who thinks they know any of the potential witnesses? Well, I'm sorry. Are there any other witnesses that are not on that list that people intend calling? Mr. Allen,
Not from us, Cliff.
defense?
Yes, Dr. Ron Niederhauser and Kate Brett, who's in this.
Does anyone think they know? I'll give,
Can you go back to the mic, please?
I will. Does anyone think that they know any of the potential witnesses in this case? Please raise your hand. Juror 66. Who is that? Mr. Allen?
Lieutenant David Manzanilla has always been a El Paso County Sheriff. He's a tall Hispanic gentleman.
As long as I answer that question.
And I was going to ask about that because you have on occasion represented governmental employees. So would it have been CSPD? Let's see. Would it have been primarily CSPD or EPSO? Okay. Right.
Most currently as you represent.
Okay. Okay. All right. Thank you. Let's see. All right. Here's what's going to happen. We are, I know it's hard to believe, but we are actually getting a little bit better and a little bit more efficient at this. This is our third day in this. The plan here is that what we're going to do is qualify 110 jurors, have them come back on April 3, and then we will select our jury pool from that. So we're getting a little bit faster every day. What that means today is that we're going to break early for lunch. And if I can have everybody come back at, say, 1 o'clock, we should be able to start on time at that point. What you can expect this afternoon is that you'll come back at 1 o'clock and the prosecution will have an opportunity. They'll have 45 minutes to ask you some questions. Then the defense will have 45 minutes to ask you some questions about all kinds of things, including some of the issues that are involved in this case. And then once we get done with that, we will proceed to select the qualifying people who will return on April 3. You've probably already guessed that there is some public or media interest in this case. You may have a spouse or significant other who is generally interested in your welfare, wondering how the jury selection is going and what's going on and those sorts of things. Here's what you can tell them. You can tell them that it is the case of People versus Letecia Stauch. You can tell them that if you are selected as a juror, you anticipate that your service would take 6 weeks, beginning April 3 and going until we're done. And that is all that you can tell them. If they ask, say the judge said, I can't tell you anything more about this. You can enlist their help in saying, help me to avoid any media exposure to this case. If there's a story that comes up, you need to not look at it. If you see a headline in the newspaper, don't read the story. You just need to put all of that outside of your mind. I know that, when I go home tonight, I'm going to talk to my wife. She's going to ask me how my day went. I'll tell her, and she'll start talking to me, and I'll tell her about something that happened, and she'll say, well, you didn't really believe that, did you? And pretty soon I'm having a conversation about what I should and shouldn't believe with somebody who wasn't even here. You can't do that. So the way to avoid all of that is to say, the judge said, I can't talk to you about this. I can't know anything about this case. I need to avoid it. Help me avoid it. If you see a story come on, turn the channel. If somebody's starting to share their opinions, tell them not to share the opinions, those sorts of things. I think that will help a little bit more. And you can say, the judge said that's what you need to do. That puts the burden on me as opposed to you. Because I know if I were to tell my wife, look, I'm just not talking to you about it anymore, it would lead to an entirely different conversation. So this way, this resolves a lot of that. Most of the eating joints are north on Tejon. There are a few south on Tejon. There's also a bistro that's in the basement. I think it's supposed to be a nice day. Don't get blown into Kansas. Other than that, it should be nice. But if we can have everybody back at 1 o'clock, one of the reasons why we're taking, I'll get to you in just a second. One of the reasons why we're taking a longer break is because we're getting this part done a little bit faster this morning than we have on other mornings. You saw people come in and hand the attorneys a stack of stuff. That stack of stuff was all of your questionnaires. And the first time they saw any of your responses was when it got handed to them this morning. Since then, we've gotten rid of about 30 people, or maybe 40. And so now they need to look at what the question responses are for the people who remain in the courtroom. I think it's fair to allow the attorneys to have a noon hour to look at that. That's what I've given them before. So that's what I intend to do now. So that's what we're going to do. And juror number 37, you had a question? Yes, ma'am.
Can we tell our court what case do they understand?
Yes. Yes, you can. You can tell them what's going on, and you can tell them everything about how long your service will be. And what I can tell you is what the attorneys have told me. They anticipate that presentation of evidence will take 6 weeks. Deliberation is not included in that 6 weeks. So that would be the end of evidence, and then there would be deliberation after that. So there'd be some time after that, but they say 6 weeks. Juror 38. No, you might still be dismissed on April 3. Here's, as I said, I've done really long cases before, and here's what I learned. And it's not any secret. We always select more jurors or have more jurors come back than what we're going to need. The reason for that is because the attorneys get peremptory challenges. In this case, they each get 16 peremptory challenges. That's just what they're called. And they get to excuse a juror for any reason or no reason at all, pretty much. So each side has 16 of those, okay? Then we're seating 18 jurors. In addition, I'm asking you how your lives are now going forward. My experience has been in selecting, especially in selecting cases involving jurors who are going to be here for a long period of time, circumstances change between now and the time that they come back. So it would change between now and April 3. It could be that somebody unexpectedly passes away. It could be that somebody loses a job. It could be that somebody has to move. It could be that somebody a family member gets sick and you have to take care of them. You weren't anticipating that. So generally, we lose about 27, 28% of people because of changed circumstances. In addition, there's going to be other reasons that may occur between now and April 3 why a juror may not be able to sit. I've had some jurors come back and say, thought about this. In my heart of hearts, I just can't do it. For a lot of different reasons. And so we end up losing jurors. So that's why we're looking at 110 to come back on April 3. And then, but if you need a letter from me saying why you're here today, why you're going to be back on April 3, if you're still standing at the end of the day, I can get that to you so that your employer knows you're not off on a lark in Cabo or something like that. So, but that's sort of the process. Does that help? Does that help you understand what we're doing here? Okay. All right. Juror 55 in the back. No, hallway. Yeah, you'll be in the hallway at 1 o'clock because we open the doors. You guys can't get in them until we open them. So my hope is that we will be opening the doors, have everybody come in. Does that answer your question? Okay. Juror 40? Yes, ma'am. We'll get to that at the end of the day if you're still here at the end of the day. Juror 53. Never too late. Okay. And the question is, and how long ago was that? Okay. The question that I would have for you is there anything about that that you think would cause you any difficulty judging that person's testimony? If it is the same person, would you be able to judge that testimony just as you would testimony from somebody you didn't know? Okay. Thank you. Anyone else? No? All right. All right. Thank you. We'll see you back at 1 o'clock. Thank you all. All rise for the jury, please. Are you back this afternoon, Beck? They're switching out. Okay. Perfect. Thank you. You may all be seated. Record should reflect the jury has left the courtroom. Then we'll reconvene at 1 o'clock, and we'll go from there. Oh, no.
Y'all wouldn't believe me if I told you. Lord God. I've got some interesting coworkers. Yes, I do. It's ridiculous.
And I mean, your opening statement is like,
Media, do you think that the media, and I'm not casting aspersion, but do you think the media reports all the facts?
No.
Do you think they report the facts accurately?
Mm, no.
Okay. And so with that in mind, do you think that you can set aside what you've heard in the media because it's not the full story? And in fact, it's not evidence in this case. Do you think you could set that aside?
Yeah. It'll be difficult, but you know, it's something you gotta do.
But you think you could do it? Okay. What about juror 14? I think you did not raise your hand either.
But you just stated about baby justice and being fair.
Yeah.
I have real strong negative feelings about the whole judicial system.
Okay.
I don't believe in it. I've known firsthand, I've seen a lot of unfairness and discrimination,
Okay.
and that goes from the judge to the DA to the law enforcement to everything.
Okay.
So I do have very bitter feelings about the whole judicial system. I think it's messed up and
Okay.
it needs a lot of work.
Okay. So let me ask you this then, with that experience in mind and the things that you just expressed, which are totally valid, you can have those opinions. Do you think that you can set that aside and judge this case based on what happened in this courtroom or not?
You know, to be honest, I'm just so bitter because what I've experienced through this court system, I really don't think so.
Okay. And so that's based on your own personal experiences? Okay. Thank you for saying that. Number 2, I think you also did not raise your hand when I was asking you.
I missed it, I'm sorry.
Oh, that's okay. So when I was asking about, can we all agree that we're gonna be open-minded and be fair and unbiased in this process? Do you agree that you can do that? Yes. You do agree. Okay, thank you. Number 4, what about you, sir?
No, yes.
You do? Yeah, okay. And I believe you are an engineer in the Navy, is that right? Okay. You have to say yes or no, otherwise. she
Oh,
takes
yes.
it down.
Yes, I am an engineer. In the Navy.
And by the way, if anybody messes that up, I'll be the one that gets in trouble, not you guys. I've already given her permission to throw stuff at. Does 1 + 1 always equal 2? Yes. Okay. What if there's a negative integer? Can that become 0? Okay. So is that kind of a way of thinking about, there could be 2 different perspectives about something that may seem obvious to people?
Yeah, absolutely.
And what are your thoughts about that? How do you think that might apply to what we're going to do here?
With
You're gonna hear witnesses.
Yep.
That come in and give you descriptions about what they saw, what they heard, what they did in this case. And then you might hear another witness, maybe from even the defense side, that comes in and says something totally opposite of that. How do you reconcile those things?
I think if it was 2 credible witnesses, they both raise their right hand and tell you 2 completely opposite things, I think they cancel each other out.
You think they cancel each other?
Yep.
Okay. Everybody hear what Mr. Number 4 said? That's so weird to say Mr. Number 4. Everybody hear what Mr. Number 4 said about that? Anybody have any disagreement with what he said? Not seeing any hands. What about number 6? How are you doing so far?
I mean, I feel like my previous statement may have been sufficient. Just in given what I already know about this case and what is being defended. At the end of the day, I feel like my mind is made up. I don't believe that there's any evidence. So.
Okay. You haven't had any evidence yet, correct? Of what you've heard in the media. which you talked about earlier. Again, yes, a yes or no.
Yes.
Okay. If you are on, let's assume that you're on the jury right now, and you haven't heard any evidence with what you have in your mind, how would you have to vote, guilty or not guilty?
I don't know the answer. Given what has already been said by you earlier about what we're gonna see, what we're gonna be shown.
Okay, so here's what I'm getting at, is that the prosecution, so as the district attorney and every DA in my office, that's a deputy DA, we have the burden of proof. If we don't prove a case, then you have to vote not guilty. So if, as you're sitting here today, you haven't heard any evidence. So if we said, okay, now you gotta give us a verdict, what would your verdict have to be under that guideline?
Prior to,
Okay, and so if we don't satisfy our burden of proof, so we don't give you enough evidence to prove that the defendant committed the crime that I talked about earlier, would you feel comfortable setting aside what you heard in the media and voting not guilty? You wouldn't? Okay. Does anybody agree with, Mr. number 6? Okay, I see a head nodding and you are number, I'm not sure what number you are actually. You're 40, okay. So you all spread out.
Have to say not good,
You were saying that he would have to say not guilty.
just agree.
Okay. And are you comfortable with that, holding us to our burden? We're gonna come back at the very end of this, after all the evidence has been presented, and we're going to say, we expect the jury to hold us to our burden. But if we have satisfied our burden, we're gonna ask for the jurors to find the defendant guilty. Are you comfortable with that process?
Yeah.
Okay. Part of what we have to do as prosecutors is present evidence. So every single bit of evidence that we're going to have the jury consider in this case is going to come from this witness stand up here. So people will get on the stand and they'll testify, they'll take an oath. You'll see pictures, you'll probably see videos, you might hear audio recordings, including some of those pictures are going to be some really horrible things. You're going to see a decomposed 11-year-old boy who has suffered horrific injuries. Do you think, as you sit here, that you can do that? Look at those things and consider whether the defendant is guilty or not guilty based on what we're presenting. And I see Mr. 55 is shaking your head. I think no. Correct. So tell me what's going through your mind. Okay. Okay. That's a different topic that I want to touch on. I'll tell you a story. Several years back, I was doing a different murder case prosecution. One of the people that was in this type of a group had previously worked in the coroner's office. But only worked there for a short amount of time. We're asking him questions about, could he do this job and see those types of pictures. And then he ends up on the jury and we get to the autopsy pictures and they can be shocking. I mean, if you're not used to seeing that kind of thing. And he immediately shot up out of the seat and had to run to the bathroom. Lost his basically. So that's the kind of thing that you're going to have to do if you end up on this jury. And so it's good that you let us know that. If you don't tell us those things, then it's going to be a difficulty for you, then we don't know it, right? And so let me go here to the front. 24, thank you.
I think I'll personally have a problem like stomaching it. Normal circumstances, I might be able, but I have a problem with it.
So I'll tell you another personal story about that. When I was in law school, we had at the school that I went to, the Defender Project, whereas after your first year, your second year of studies, you could do the Defender Project, and I did that. And I had young kids, they were 2 and 5, I think, at the time, 2 and 6. And one of the cases I got assigned to was a young child death case. And it was hard because it was personal. It made it seem personal. And so you're saying that might be difficult for you because of that personal connection? Anybody else feel similar to that? Yeah, let me get your number. Thank you, sir. 35.
Yeah, I kind of feel the same way because I have a friend.
How long ago was that?
About 10 years ago.
Was it here or somewhere else?
Something.
Okay. You think with that experience in mind that you could work hard to set that aside and just judge this case based on the evidence in this case?
Probably could, yeah.
Probably could. Okay. And going back to you, number 24. If you're expressing some reservations about whether that would be something you could do or not, you think you can judge this case based on this evidence and put that personal side to the side and judge this case just on the evidence?
I don't think you would, affect my judgment on the case. Thank you, something like that.
Okay, okay. Any other thoughts on that before I move on? Yes, thank you. You said 30, 36? Yeah, 35 over there. Yeah. And that's a personal thing. You're already sort of answering your own thought as you're saying it, knowing that if you see something that's shocking to you, it's probably going to stay with you for a while. I can tell you the first murder scene that I went out to, and we go out to murder scenes with the police officers, I still remember about that. Very good at things, smells, images. And so you have to work through them in your own personal way. There's no magic way to get past that, but it is a consideration you'll have to think about. How do you as a person in everyday life, because we do this every single day, we hear stories from people and we're able to reconcile two different viewpoints, kind of like what I was talking about over here, two different viewpoints about a singular event. Maybe two people go to the same party, they have different experiences, they describe the party differently. Doesn't mean the party didn't happen, right? It's just their own different perspectives. How do you judge somebody's credibility in that scenario? '29. You've been quiet today. Okay. Have you ever had two friends tell you about something and then you listen to them and you think, oh, this guy is full of baloney, this guy's not? How did you do that?
You're 29. Can
Yes.
you speak up a little louder so that we can hear you better, please?
Yeah. So basically, he was saying that he would listen to both sides and try to figure out which one was telling more true things, basically. I'm paraphrasing. Is that a good paraphrase? Okay. Again, speak up. Here's a funny thing, and I know right where you are. You're a shy person, it seems like. In school, I'm still actually a very shy person. I used to really hate talking in front of people. And so when we had those assignments where we had to give a presentation to the class, I would hide in the back, slink down in my chair, get sweaty palms, not want to get called on. And then I'd finally get up there and I'd fumble my way through it. So of course I become a trial, right? So I know exactly where you're coming from, but to help us flesh out who's going to be good jurors for this case, we got to get into some of those topics. Okay, so my apologies for calling you out like that, but we just have to have those things happen. Yes, ma'am. And you are 37, I believe. Or you gonna be 35 too?
I was just gonna respond to the question. of the Teenagers. Just the way it is. So
Are you able to work through that and figure out what happened?
yes, I mean, the thing is,
How do you determine somebody's intent, what they intended to do? Without getting into whether they said they intended to do something. You think of any experiences where you have to figure out somebody's intent? Okay. And you are, again, I believe, 17, thank you. You get a feeling? Okay, all right. So let's, yes, ma'am. Not 35, 38. That whole row is now 35.
in my line of work, intent is, I learned a lot about past.
I don't know what SMI is.
Seriously mentally ill.
Okay,
So I use SMI for state very well. I see a lot of people that have prices. One of the- On my decision.
okay. So let me try to see if I understand what you're saying, just so we're all on the same page. You look at their actions to see if they follow through with,
Before they even got to this, what was their past history? I've done habitually in the past, and now here they are in front of me. I'm kind of like the pre-batch and then they go.
so. Are you saying actions can sometimes be louder than words?
Yes.
Okay. Anybody agree with 38? Anybody disagree with 38? Number 19, you raised your hand really quick. And I asked you, right, did you take a break? You raised your hand really quick when I said anybody agree with what, actions speak louder than words. Why was it so quick? What was in your mind? Actions always speak louder than words. Okay. Anybody disagree with 19? See no hands. So let's do this. This is going to be a really silly example. Let's say that it's illegal to buy more than 1 pound of ground beef at the store on any given day. And I go in the store and I buy my 1 pound of ground beef. And I go out to the car and then I come right back in and I buy another pound of ground beef. I do that like 4 or 5 times. Am I exhibiting an intent there? Number 21. What about, yeah, so what about that description tells you I knew that it was illegal? Okay, so. Again, is that an example of action speaking louder than words? Anybody disagree with that idea? 36.
The one. That was similar during COVID, right? Let's be honest, right?
That might be an excuse. Anybody have thoughts on what 36 just said? No?
I think it's right.
You don't think what's right?
Greedy.
Okay,
Because you're hurting someone else.
so you would convict me for buying too many pounds of ground beef under that scenario? And it's okay, the answer is yes. Judge talked about recipes earlier, recipes to likening it to what we have to prove in a criminal case, the elements of a crime, and he used the Denver omelet idea. That's similar to what we do in criminal law, where a particular crime has elements that we have to prove. What we have to prove as prosecutors is only those elements beyond a reasonable doubt. All the side stuff, we don't have to prove. Who here thinks motive is one of those things we have to prove to achieve our burden of proof? Motive. Okay, and again, number 17. You think motive helps?
Sure.
Okay. If you're on this jury, do we have to prove motive to you to satisfy our burden of proof?
Everything else has to get there.
Okay, all right.
Mr. Allen,
Yes,
thought you had a hand
Oh,
for
okay.
number 4.
Yeah, it's, I mean,
thank you.
you have to meet all the burden of the charge. If that's one of them, then you have to meet that. But,
Okay.
you know, you're just driving down the road and you took your eye off the wheel and you ran somebody over and killed them. There's no motive there. But you don't charge them with that. You know what I mean?
Yes,
So that's important. That's an important piece of it.
it might be a good way of understanding why something happens, right, is what you're describing. And I think that's the human condition, that when we hear of something happening, we want to know why something happened. Does everybody agree with that? Does anybody disagree with that? As humans, we want to know why something happened. Here's a, maybe an eye-opening thing for everybody. Motive ain't one of those ingredients in the recipe for the crimes that we have charged in this case. We don't have to prove motive. It's not one of the elements, not one of the ingredients for that Denver omelet that the judge was talking about. Anybody have any thoughts on that? Anybody have any issues with it? Or does it make perfect sense to you? I'm gonna call on, I've been meaning to get to you number 34.
No, that's good to know, but that's not part of the, I think it was just. I was thinking back, I was doing that to the. Why you use like email. Did that 4 rounds around me.
You're good with that. Okay. And I think you were one of the people that had mentioned, I think you agreed with one of the other jurors earlier this morning about having heard some stuff about the case and then sort of wanted to retract what you'd put on your questionnaire.
Right, yeah, I didn't, just explain that. But hearing stuff in the news, I can work down in that. After going through the process, listening to what it. Frustration of.
Lady Justice.
Yes,
Yeah.
right. Really helps me with that. Why did it explain that?
So with your experiences in mind, having worked in that area, having seen some news, having put the things down that you did on your questionnaire, do you feel like you can be a fair and impartial juror in this case and just judge the charges against this defendant based on what happens here in this court?
No doubt.
Yeah, no doubt that you could do it. Okay. Does anybody, we already heard from number 14, and I think number 13 as well, kind of feel the same way. Anybody else feel differently than what, 34 just said? Anybody feel like they can't be fair and impartial here in this case based on things that you might have heard or seen in the media? Okay, yep. Number 6 is raising your hand and based on the stuff we talked about earlier.
I would like to mention that I feel like I've learned more about this case in the few hours I've been in this room than from the media.
From what's happened here.
Yes.
Okay, so that gets to the concept that the judge mentioned earlier that the only people that can give us evidence in a case come from that stand. So we're not witnesses in the case. So myself and the other 2 attorneys from the prosecution and Mr. Tellini and Mr. Cook are also not witnesses. So the things we say is not actually evidence. What do you think about that? Does that change your opinion as to can't consider necessarily what we say as to weigh guilt or not guilt?
I understand that what has been presented this morning is not evidence, but it was said that what you had said was true. Before this being in here, there was very limited knowledge I had of this case. I knew a boy had died. I knew who the accused was. I knew he was found in Florida. Since then, I have learned that he was stabbed multiple times, defended himself, was shot, was beaten, was driven to another state to be disposed of, and all of that stuff. And then I was told that everything that you had said was true. And that the reason we're here is because they want to convince us that she was legally insane at the time of committing these acts that we've already been told happened and were true, without a shadow of a doubt that this boy is dead. I can't see myself looking at this any differently than the drunk driver killing family.
Okay.
Whether or not they remember it, they were sound-minded when they did it, it doesn't matter, they still did it.
Okay. So let me clear up one thing that you said as it relates to the law, what it says about this process. We have to prove that all the elements for the charges that we've charged here, all the counts, we have to prove those elements beyond a reasonable doubt to whoever ends up on this jury. We also have to prove, or you could say disprove, prove that the defendant was sane at the time of committing those offenses. This table here, the defense table, doesn't have to prove anything to anybody. And that's based on our constitutional provisions that are unique to this United States. No other country in the world has those same provisions in the law or allows defendants to have the rights that they have here in the United States. Does everybody understand that as it relates to who has to prove things and who doesn't have to do anything? Does anybody think anything differently about that? That they think they want the defense to prove something to them? Not seeing any hands. Okay.
Yeah,
Yes.
this is probably the thing that I'm struggling with the most.
Okay.
So if everybody sitting there agrees that this happened, including the defense, but they have a defense, isn't that implied that they have to prove that she wasn't in sound mind when this happened?
So the answer is no, they don't have to prove a single thing. They raise the defense, it's called an affirmative defense. And then we have to disprove it. So let's use this as an example to talk about this particular point. If, say there's a bar fight where one guy punches somebody else at the bar, and it causes that person that gets punched to have a broken facial bone or something like that, that would be a felony offense. But maybe the person that threw the punch says, yeah, I threw that punch because the other guy pulled a gun on me, so I punched him before he could shoot me. So raising the affirmative defense of self-defense. So we would have to prove in that scenario, one, that the person that punched actually punched and caused that broken bone. But we also have to disprove that it was self-defense. Does that make sense? I heard it over here, so yeah. But does that make sense to you, number 4?
It does make sense, but what I'm laying out is I'm just kind of struggling with this concept.
Yeah. And I think it's a reasonable concept to struggle with. If you haven't gone through this process before, it sounds odd that, they don't have to do anything, right? They can just sit there. I know that they're not gonna do this. They're really good trial attorneys. But they could sit here and not say a single word, for the entirety of the case. And if we don't meet our burden, you have to say not guilty, even if they don't do anything. You don't have to prove a single thing.
You've met your burden.
If we meet our burden, then you can vote guilty. If we haven't met our burden, we have to vote not guilty.
I guess what I'm getting at is if all the evidence points toward meeting your burden, then if the other side says nothing, why would anybody here vote the other way?
Okay. And really what you're saying is that you're assuming that we have met our burden in this hypothetical scenario.
Right.
And then you're absolutely right. If we've met our burden and the jury feels that we've met our burden, the right verdict would be to be not guilty if we've satisfied our burden. So you're hitting on exactly the right thing. It's just struggling, I think, in talking about these concepts that you don't have to deal with every day like we do. But you're talking about the law exactly the right way, just in not the way we talk about it. Does that make sense? And so I heard somebody back here say yes or
Sense of it's I've seen.
And you're 38.
So I've seen this, person out of solar, I've seen here, because I deal with that type of population. So I think you not. So I think that would be clear for him to.
You.
But I'm just talking.
Yeah,
Like,
yeah.
if we were together, that it is possible. I, you know,
And so actually, we're going to jump into some of your back. I was going to do this anyway, but you're bringing it up now. So you have that history working with mental health patients,
Yeah.
right? Would you agree or disagree that there's a wide spectrum of mental health? Lots of people with mental health are still sane,
oh, yes.
know what they're doing? That's a yes or no.
Oh, yes,
Yeah.
yes.
And can form intents,
Yeah.
intentional with their actions. And getting back to what you said earlier, their actions can speak louder than what they're saying with their mouth.
Yeah.
With your background in mind, do you think that this type of case would be good for you or not good for you? Okay.
I believe I know both sides. All studies for mental health, person, in-person outpatient, used to crisis. And I see both sides, I've seen people that. I know nothing about this case. Yeah, I was like, I know nothing. But just
Anybody hearing 38 say that, have any opinions that they want to share? Oh, you had your hand up for a second. Yours. Anybody else? Back here, number 2, thank you.
You know, number 4 brought up the issue of, what do you have to prove? If the defense is not guilty because of insanity, who it has to address the sanity issue?
Okay.
Is that part of your element?
So that's something that we have to disprove. Yes, so we have to prove that she was sane at the time of the offense. So let's talk about that for a second, and I want to come back to 35, 36, 38. I'll come back to you in just a second. The insanity part only applies to at the time of the offense. Meaning that we have to prove that she was sane on January 27th, 2020. If she became insane later than that, that's not have nothing to do with this case. If she was insane before that, but then got better, has nothing to do with this case. Does that make sense with what you're saying, sir?
But you have to address it,
We will have to address it, and we will address it.
because you said they could do nothing. If they do nothing and claim, not guilty because of insanity, then there's no evidence.
That when they claim that, then we automatically have to do some things to disprove it, okay? I'll get to you in just a second, okay? What are your thoughts about what I just said? It's at the time of the offense, not other times, that matter.
Typically in my trauma, severe trauma, definitely background, is very important. That's gone crazy. That's right there. Unless there was something that triggered her.
5 minutes, Mr. Allen.
So they just, not that they can't. Seen some.
Okay.
Or
We are going to have doctors testifying on both sides of this case in all likelihood. And part of our jobs as prosecutors and part of their jobs as defense attorneys is to cross-examine those witnesses. You may see some of those witnesses get challenged pretty heavily, and maybe very strenuously and maybe animatedly even. What do you think about that? Do you think having maybe their doctor or our doctor really get raked across the coals, part of this fair process? Is everybody good with that? Watching that sort of thing happen? Yeah, okay. Number 73, way in the back. We know each other from political circles, right? Despite the fact that we know each other, you think you can set our a friendship aside and just judge this case based on the evidence that you might hear in this case? Mr. 66, you put down, I think, maybe some hardship because of work stuff and representing Teller County. You have to tell us whether you have the time to serve on this jury if you end up. I'm about out of time. The judge, as lawyers, we want to get up here and talk for 2 hours, but he won't let us for some reason. Is there anything gnawing in the back of your mind saying, I wish Michael would have asked us this, that, or the other thing? Because it's important that they know this about me or my viewpoints. Anything like that that you want us to know about right now? Yes, number 55. Okay. Okay, thank you. If you couldn't hear, did you hear it? Anybody else have anything? Yes, ma'am. We have
Number 33.
33, thank you.
Sorry. I just want to say, I don't want to see awful pictures and but I am so passionate about this country's students. To be it feels weird to sit here and hope that I might be able to be involved. Such an important.
That's one of the things you marked on your questionnaire was that you had seen some stuff and then you realized the story was too sad for you, so you avoided it after that. You think you could be a good, fair, and impartial juror in this case if you're in a public jury? Okay, thank you, Judge.
Right. I just wanted to touch on a couple of things because especially to address a concern that juror 36 had raised. It's not well known, but I think it's the whole state. I know certainly the Fourth Judicial District offers counseling services to any juror who has served on a criminal trial. And I've offered those services in the past, and it's a confidential, oh, sorry. The Fourth Judicial District offers counseling services to any juror who has served on any criminal case because there are all kinds of things that you see. So that is one thing that is available to jurors if you are selected to serve as a juror on this case. In addition, counsel approach, please. Mr. Cook.
Good afternoon, everybody. As I mentioned this morning, my name is Will Cook, and I represent Letecia Stauch in the blue shirt. So this is voir dire. This is not really jury selection. Probably mentioned that this was more like jury deselection. Jurors are being cut loose and kind of the survivors get to stay on the panel. So I don't get to say, I want you go on the jury. We're deciding who's not going to be on the jury. So this is a deselection process, but voir dire, it's a French term. It means to tell the truth. And as Mr. Allen alluded to, you know, this is a safe space, except for everybody listening on the webinar. But it's a safe space, all right? You're not going to get in trouble if you say something I don't want to hear, the judge doesn't want to hear, or Mr. Allen or the other DAs don't want to hear. We just want to know the truth because it's important. We're deciding a lot of important things as jurors. And that's why we're given the opportunity, everybody, to ask questions of each and every one. So just starting out, and I'm not going to carry a sheet around. I'm just going to kind of point to a person and say, what's your jury number? So let me start. Juror number 4, how are you, sir?
Good, how are you?
I'm good, thank you. Thank you. Have you ever seen, I think they've done a remake, but there was an older movie called 12 Angry Men.
The original black and white.
The original?
Yes,
Have you seen it?
not long time ago.
Okay, has anybody ever seen the original 12 Angry Men? And man on the front row, what's your jury? 24. When did you see it? How long ago did you see it? Okay, so you have a good memory of it. And do you remember Henry Fonda was in it? Do you remember the guy who played Patton a long time ago, George C. Scott? He was one. Okay. But you remember the premise. We sat through the jury trial and everybody was like, let's convict this guy. And then Henry Fonda, who was kind of the nice fatherly type, said, well, let's look at this. Let's look at this. Let's look at this. And eventually people started saying, yeah, I don't think, I'm going to come back on my guilty vote. I'm going to go not guilty. And you remember there was one guy who maintained to the very end, he's guilty, he's guilty, he's guilty. Do you remember that? Vaguely. That actor was George C. Scott. I think he's won some Academy Awards for different things. But he was angry. Do you remember that? Okay. And eventually he came around after Henry Fonda talked to him. That was the whole premise of the movie. And he said, not guilty. Do you remember that? And this young guy was acquitted. And it turned out the jury who wanted to, the angry juror who wanted to pick, he had some problems with his own kid, and the defendant was a young guy and reminded him of the kid. And it's, do you remember that being the situation? Okay. So we want people that are fair and impartial, but the reason why Mr. Allen gets to ask questions and why I get to ask questions is our ideal juror looks different. What I think is an ideal juror as a defense attorney is very, very different than what Mr. Allen thinks is an ideal defense attorney. I want to pick Henry Fondas on my jury, and the people want to pick more along the lines of George C. Scott. Okay? That's what we want. With this process, though, generally speaking, we land somewhere more in the middle. And that's the way it's supposed to work. You want some people on a jury that have had good law enforcement experiences, bad law enforcement experiences, some that think this way, some that think that way. That is what society is like. So are you okay with this idea that we want a little bit of everything? That is a jury of your peers. It's not just all people that feel one way. It's not all people that feel the other way. But it's a nice mix. Okay. All right. Juror number 4, how do you feel about that? I mean, do you think we should have all people that are pro prosecution, or some people that, you know, when I was a kid, I got arrested for this, got put in the juvenile home, and it was unfair. The cops were wrong. They, roughed me up. Do you think it's good to have a nice mix?
Absolutely.
Okay. Mr. 34. What do you think about that idea?
I think it'd be a good sign.
Needs to be a good mix. Is there anybody here that thinks, or is there anybody here that thinks that, you know what? We don't need this long jury process, this jury selection, deselection, whatever Cook calls it. Let's just get the first 12 people up here and let's do this thing. Anybody that feels that way, or do most people, and I want to see a show of hands on this one, do most people feel that it's good to have a mix? It's good to have people from all walks of life and all experiences on this jury. Show your hands if you agree with that. Is there anybody that disagrees with that? I think I don't see any hands. Okay. In Mr. Allen's statement, he talked about Lady Justice. That she's blind, she has a sword, she has scales of justice in her hands. She's not blind, she's blindfolded, I should say. And he says, well, that represents fair and impartial. You come in as jurors, you come into this process blind. You don't know what's going on. So you're fair and impartial. You have no prejudgments. Now, number 13. 13, juror number 13. Here's what my concern is. I've been looking over a whole lot of jury questionnaires, and it may not be you, but there's a lot saying, I think they know more about the case than I do. I'm the defense attorney. What they wrote, they know a lot. They were like, I've been following this since day one. This was search teams. I watch it every day, and I even watched it this morning before I came to sit on this jury panel. When I hear that and I see stuff like that written on a jury questionnaire, I think Lady Justice has had her blindfold taken off with respect to this trial. And that's a problem for me, whose only job and only duty is to work for Ms. Stauch. Can you see where
Yeah, I agree with you.
I'm gonna get a little heartburn over that? How do we get around that? Or how do you get as a jury? You're on this, you're being told, hey, this is the way you need to think. You're sure. You've written down, a dissertation on all the facts you know about the case.
Gotta listen to those guys.
You gotta listen to those guys. Okay. And what can you tell me to make me, and I know it's not your job to make me feel better. But as the defense attorney, when I see that people have been following this, what can you tell me to ensure that some of this isn't gonna leak over into situations?
Just gotta block all that out and go with what the witnesses say. You just can't go by what you know previously.
Okay,
You just gotta shut that out and clear your mind
okay,
and focus on.
all right. And did you know about stuff that was going on? Yes, in this case. A lot or a little, sometimes hear it on the news.
The news, media.
Okay. And, you're number 6. How are you, sir? I'm okay. Okay for a Wednesday afternoon, but, you said you know too much, and even what you heard more this afternoon hardened your position on how you feel, correct? Do you think it's hard to hear all this stuff in the media for months, years and years? Like, court proceedings, the judge ruled this, going to trial, probable cause. Do you think it's hard to just walk through that door and all of a sudden you're cleansed of all your memories and you don't carry anything forward with you? Do you think that's a hard sell in your mind? Why is that?
Already have all of those things in your mind. I feel like my stance is hardened. I have opinions and bias and everything else. My knowledge of the case before this morning, and you saw in my questionnaire, was I don't know it.
Yeah,
I'd forgotten about it. It's been 3 years.
yeah.
I made the mistake of Googling it when I was sitting out in that hallway.
Mm-hmm.
That's when I realized those 3 things that I mentioned earlier in Mr. Fountain. Anything else that I've learned since then was, in my opinion, insane or not, the act was still committed.
And do you think if you've been following this for roughly 3 years, think if you've been following it a lot since day one up to today, do you think it's hard for you to just, there's a following this, just deprogram yourself in a matter of hours? What you juror number, was it 33? Hi, how are you? I'm good. So you're a human resource administrator, and I was looking at your questionnaire. Sometimes do that. And it said that you think you can be fair. Want to hear, both sides of the story. Is that correct?
Well, that's what I do in my job.
Okay, okay.
Just have something brought to me and then just fire somebody up.
It's important to hear both sides in a disagreement. Okay? Does everybody kind of agree with that when determining the outcome of a dispute or argument? Good to hear both sides. If there's anybody that thinks the whole, I want to hear from both sides is a bunch of baloney And, you know, that's not the way to decide things. Raise your hand if you feel that way. I don't see any hands. So. The judge, Judge Warner, he indicated to you that the burden of proof is on the prosecution. Burden of proof, the job, the duty, the responsibility, whatever you want to call it, is on them. They have to prove the charges beyond a reasonable doubt. She's presumed innocent. And if you're one of the final people to be picked to sit on this jury, the final 12, you will be determining this dispute. This dispute being whether she's guilty or innocent, or whether she's insane or not. And you're going to get a jury instruction for one of the final jurors that says the defendant may or may not testify. And the fact that she does not testify, you cannot hold that against her negatively. And so what I'm trying to tell you is, you may not get to hear both sides of the story. And you can't look negatively against my client who doesn't testify.
Have circumstances like that. Their side of things, or maybe they just say, then what I have to do is look at
Okay. Thank you for that. And let's. Miss 36. So what do you think about that idea? You're not going to hear from both sides, or you may not get to hear from both sides. And can't hold it against me, Mr. Tellini, or Miss Stauch, most important. Well, I'm
Assuming that you're going to present another side.
well. You're now. I'm saying you. She may testify. She may not. And the fact that she doesn't testify, you can't read into it, as the judge said earlier. Hey, if I was charged with something this bad, I'd get up there and scream to the world. You know, whoever would hear me that I didn't do it. Okay. But you understand, we have no burden of proof. We don't have to say anything. Okay. Judge said we could take a nap. And, you know, give me about 6 or 7 weeks. And if you're on this jury, I think we're going to be taking afternoon naps together. But you understand my point. This is the first day you've been here. We've been in here 3 days. So, you know, if I'm having a bad week and I've been, 7th or 8th week of trial, I may not off. You can't hold that against me. You understand? Okay. And the reason is because the burden of proof. They have it 100%. So, and you're number 37. How are you? I'm good. So on your questionnaire, you said that you're traveling March 27th through the 31st. What is that for? Spring break, tickets bought, everything like that, flying, driving, spring break with kids and family and all that. Okay. And how old is your child? 11. And I'm not asking that for any sinister reason. So, would it be a hardship for you to miss the spring break? Okay. And why I'm asking is, you know, we've already been picking a jury for a couple of days. We're going forward. If this isn't the right case, and this goes out for everybody. If this isn't the right case for you, or, you know, I don't want to look at photos. I don't want to remember that. I want to take the vacation with my family. My kids are only little once. You know, those can be valid reasons for, you know, getting put on a shorter trial or, you know, not having to serve on this case. If you feel, I mean, there's no wrong answer and you're not going to get punished. But if you feel like this isn't the case for you, due to the length of it, missing having a vacation, family vacation already planned, due to the nature of it, now is the time to let the judge know, or the courts, or me, and or Mr. Allen, whoever may be speaking, and arrangements can be made.
Yes, we start on April 3. We come back on April 3. So it's not next week. What will happen is at the end of today, you'll know whether or not you have to report back on April 3. Does that answer your question?
And you were you were in March, you say next week for spring break? Okay. Other than the vacation stuff you put on your questionnaire, is there any problems that you may have with this? What are your concerns? Okay. Okay, now I saw that juror number 38 seated next to you. You said that you're the only one working right now in your family? Was that you that put that?
I'm the only one.
Yes, juror number 38. You were the only one working? And so when it asks for hardships, you put that down. I mean, is this something you can get by? I mean, I don't want you.
And so it is something that my day job would be affected. But I do crisis at night.
Okay,
So it's call things.
okay. Okay,
Fine. Would it be hard? Yeah. I don't know if my work reimburses. But I also have private practice as well.
okay. Okay. And thank you for that. Juror number 39, how are you? Good, good. Do you have any hardships, or based on what you've heard?
One of the things
Yes. Okay, here's what I don't want and the judge doesn't want in a juror. That, and Mr. Allen, we don't want a situation where 2 weeks comes by and we're the first, second week of May, still have 2 or 3 weeks left. And your workplace is falling apart. You've been gone for several weeks. It's a disaster there. You're worried about money. You're worried about picking up kids. You know, everything's being held together by duct tape in your life. And you're thinking more about your problems and what you're missing and who's going to cover your next shift than you are listening to sworn witnesses who are here in the witness box testify. So that's what we cannot have in this room. And if you think it's going to be a problem, let us know. Like, there's no shame in that. There's no, if you can't serve for 2 months on a jury, you can't do it. And if it's because of work, if it's because you don't want to look at photos of a decomposed 11-year-old boy and autopsy photos of that, then that's fine. There's other cases. There's DUI cases to be had. There could be a slip and fall, or, a case with, me rear-ending Mr. Allen in a parking accident or a driving accident. There's lots of different cases that you can be on. It doesn't have to be this case, which is super high profile and super long. So what do you think? Are you the right person for this case? Well, now's the time to say it. And we kind of need you to say, like, yeah. Okay. And why do you say no? Okay. Okay. All right. So you're worried about the photos. You don't know how it's going to affect you, do you? Okay. And there's a lot of other places you could serve your civic duty in jury trial capacity besides being here. Okay. Is there anybody that feels the same way as juror number 39? It's like, I want to do it. I want to serve in this case, but this isn't the one. There's other places I could be, and I'm not the best juror. So I want to get my calendar up. Anybody up here?
So just kind of ask you a question, what day is the 3rd of April?
That's
Is that
juror number
Monday or
4.
This Monday.
April 3 is a Monday.
Oh, okay. So, yeah, kind of.
Okay.
I have travel plans set up for the 2nd and 3rd, that Sunday night and Monday.
Okay. I think you should be fine. But I'm gonna let the judge address that. He's the scheduler. I just talk. So we've got you. Anybody else in this section, the front section? Okay. And back here, raise your hands again. Were you 24, ma'am? Now, I know I saw when the photo situation was asked by Mr. Allen, I was looking at you. You got very emotional. I mean, not very, I mean, you weren't on the ground in the fetal position, but, I could tell you were upset. And you're pregnant. Is looking at these photos we've discussed, and you're going to have to see. You've got to look at them if you're on this show, and they're bad.
You could say that, I mean, I have a hard time articulating, so I want to be emotional when I start to talk.
Yeah.
But I would say I'm typically not an emotional person. I not want to necessarily be on this trial. That being said, I believe it's my civic responsibility. Personally, it would be pretty big inconvenience to my life.
Okay, well, here's the thing. We are going to be having people in the rest of this week, next week, doing the same thing, okay? And if you think you're going to get squeamish, if you think there's going to be pregnancy issues, if you think, you know what, I've got a new life growing in me, maybe I don't want to be a part of this proceeding for the next 2 months, that's fine. If you don't think you're the right person for it, you're not the right person. Here's what, as I said, we don't need heroes in here. We need jurors that are fair and impartial. Okay. And you can serve in a different capacity. You could go do a 2-day DUI trial. You could do a slip and fall. You could, as I said earlier, you could do a car accident, PI case, something that's a lot shorter and something that you're not going to take home with you. And it's going to be in your data bank of memory for the rest of your life. So I think this case is just not the right case for you, and you need to something else?
Yes, I would say like particularly, I don't want to do it, but if it was asked,
Okay.
that's me being.
Well, we don't pick,
Deselect.
we unpick.
So, for that reason, like I still believe like I could be a candidate per se, but I mean, me personally, I'm not.
Okay. And you do have some say in it. Like, you can say, I don't want to be on this case. And, okay. Okay, who else back here? And yes, sir, Mr. 35, I know you talked about some of the photos too, and it's seen a shooting up close and personal. What are your issues?
My issue would be the photos,
Okay,
so, I feel like
okay, thank you for that. And did you have your hand up? 36?
Basically, for-
You don't have to explain yourself to me, the judge, or anything.
I read the sure what they call it, like, press all and do it, get it done, and then. Keep transparent.
I absolutely understand. All right, thank you for that. And who else going down the list? 37? We had a special education teacher this morning, or maybe it was yesterday or Monday. I'm losing track of day. Anybody ever see Groundhog Day with Bill Murray? It's my life. And will be yours too if you get to sit on this jury. But anyways,
I already have kids to ask you, why would you care?
this is going to go through the end of the year. And if sometimes you have kids that maybe they're not special needs, but maybe uh, they need more out of school than some other kids. And if you're teaching that demographic, then it could be harder on them. You're more of a rock, more of a family member than a teacher. If you worry about that, that is fine. I think a good teacher and an
Wait. Hold on. Mr. Cook, you know better. Only one person can talk at a time. Don't talk over her. Don't interrupt her. The court reporter can only take down one person at a time. So it's important that only one person be speaking. So if the jurors would allow Mr. Cook to finish what he's saying before responding, and Mr. Cook, you need to let them answer.
She's a pretty good court reporter, though.
She is, but she's not ever going to be able to take down two people at a time. You know it and I know it, and so does she.
All right, Judge, thank you. Sorry. We need teachers. We need them in, underserved schools. I get that. If that's where you might be more valuable, then let's keep you there. We've got plenty of more people coming in. So you're worried, would you be worried about what was happening to your children, your kids over the next 6 to 8 weeks until the end of school? Okay. And as I said earlier, I want you focused on what's going on in here, to the exclusion of what's happening at your work and everything else. Are you okay with that?
I understand.
But I mean, you're okay with the idea that, hey, we can keep you teaching. And if that's what you're worried about, let's do it. Let's make it happen. We can do that. He's a judge. He's got a black robe. So, all right. Thank you for that. And who else would have an issue? And you are juror number 40. I think we talked earlier. Were you going to have some of the issues with the photos?
It's just a photo. I may react, I don't know. I usually avoid these things.
Okay.
I don't watch horror movies. And I tend to avoid paying attention to these kinds of things.
Okay.
But I'll do it.
Well, and I appreciate that. And it must be a concern for you if you've raised your hand several times and mentioned it, though.
The first time I knew,
Oh, you didn't mention it before?
because I felt like, well, it's my.
Okay. Well, you can,
That it won't cause me to cry.
okay. What about cause you to see photos of this little 11-year-old boy who's been in a suitcase in Florida for 6 weeks under a bridge underpass? And you see that,
Go there.
and then you go, somebody is going to pay for this.
No.
And because I think that's a natural reaction. Somebody's going to pay. When I see something horrific, they're going to pay, and automatically they're going to make Miss Stauch pay. That's my concern as her attorney.
I don't.
Okay. Okay.
Fix most.
Okay. But you are worried about the photos having a visceral.
I'm not
Okay. And what would your reaction be?
crying.
Crying? Okay. All right. And who else raised their hand that has issues? And you are 42. Yes, sir.
43.
Okay. And this was 43. I'm sorry.
It is, right, it's 43.
Do you know if your work pays for jury duty? Some do and some don't. Okay. But it sounds like you're not in a position to have to go without pay for 6, 7, 8 weeks if you're on the final jury panel, correct? Okay. And would you be thinking about this, and would it be, if you're losing money and you're on this jury, you're going to be going like, when can this end? I'm going to get evicted. I'm going to get my, car repoed, all this other stuff. Is that going to be in your mind? Okay. Okay. You do really want to be on this jury. Okay. Now and I'm going to finish this up, but I'm going to come back and ask everybody who wants to be on this jury. We've got people that don't want to be on it and felt that this may not be the best case for them, and then maybe you want to be it, but for financial considerations. But let me finish up with those who don't think this is the right case and don't want to be on this jury. Raise hands. I know there were a few more. And juror number 55, I think you've already spoken a couple times with the photos. You're a young man, and is it still based on what you said earlier? More. Okay. Okay. Would it, we have 1-day, 2-day jury trials. Would it be a lot easier for you to handle a case like that instead of one that you're going to hear 6 or 7 weeks of testimony? Okay. March. Okay, well, I don't think this would interfere with that, but I'm running out of time. Who over here else had their hand up? Yes, sir, that is number 49. Okay. Eh, All right.
Can you speak up and repeat?
And are you concerned that you can't get that hair tied because of your health concerns? Okay, thank you, sir. That's the information we want to hear, and I appreciate that.
You have about 4 minutes.
4 minutes?
Mhm.
Juror number 4, back to you, and I've just got a few minutes left. You indicated that you were gone or unavailable on April 3rd.
Right, I just said that. I have vacation plans for the 3rd, which is that Monday,
Okay,
when, if or when everybody gets called back.
okay. And so you will be here on that date? If
I will not, I am out of town on that Sunday night and get back on Monday late in the day.
So we start on Monday,
I know.
and you will have to be here if you're one of the final jurors. Is that something you can change, or is it set in stone this vacation?
Well, it's all locked on, so I don't know. Depends on how upset I want somebody to be with me.
Okay.
I'll put it down.
All right. And that,
So, yeah,
okay, so you're not available the first day of the regular trial?
like the rest of it, probably not a huge burden, but that just out of every day in the next like 3 months, it's like, that's the one.
That's
day.
the one you can't miss? Okay. Oh, juror number 2, just a couple more questions for you. Mr. Allen, he indicated he wanted everybody to come in here blindfolded, Lady Justice, and that was important, and that's the symbolism behind it. Okay. Do you understand my concern when we're supposed to have fair and impartial jurors and, you know, Mr. Allen spent some time talking about Lady Justice blindfolded, holding the scales of justice. And, you know, and you put on your questionnaire, you followed news articles since the start of the case till today. And it says you have a bias based on the readings, I guess the media readings. How have you been able to go from, you know, what you wrote on your jury questionnaire to you can or cannot be a fair and impartial juror now?
I think I have a very open mind and I understand that we have not had any testimony. Listen very well.
Okay. And with insanity, you said that you doubt, ask questions about the plea of not guilty by reason of insanity. You asked questions or you said you have doubts on insanity pleas. What does that mean?
I think that really is the key on this whole issue because it doesn't seem like there's a lot of discussion on the facts of the case other than whether the sane or, you know, unbalanced on the day this happened.
And how do you
You'll
feel?
have, will be testimony on both sides.
And how do you?
I know a fair amount about expert testimony. I've been a PhD professor for 13 years, business owner for 15 years. But I'm pretty good at judging people and how they testify. I've hired, I've fired,
And what do you feel about, you personally, right now, what do you feel about people that say, I'm insane?
can you speak up over here?
Oh, what do you feel right now, here today, about people who claim I'm not guilty by reason of insanity? What do you think about insanity, please?
Certainly a valid play in the court. And it's going to take expert testimony to on both sides, I think, to talk and discuss the issue.
Thank you, Mr. Cook.
Thank you.
I wanted to do a little bit of follow-up. Juror 14, I wanted to talk to you. You said that you had, you said that it sounded like you had some bad experiences or some bad opinions of the judicial system. Is that fair? Okay. And that's not unusual. And I'm sorry that you feel that way. It means that in some fashion, the judicial system has failed you, and that's bad. But I also have to tell you, from my perspective, I think people with your viewpoints make absolutely excellent jurors. And the reason for that is they come in with, they come in skeptical, and they come in and want to make sure that everything is done the right way. So the question that I have for you is, I understand that your bias, it's really against the system. Is that fair?
Yes, in a sense, it's that, it's the whole system. I've been dealing with the system for years, and I just feel that I've been betrayed, I've been lied to, my family has experienced a lot right here in this court.
Okay.
I just, like I said, I just want nothing to do with courts, the system, the whole thing. Even walking into the courtroom, into the judicial building this morning, I just hated it because I had so many bad experiences coming in here and leaving.
If you were selected to serve as a juror, one of the things that you could do is make sure that we do it right. How do you feel about that?
I just have such negativity in me, I guess, but, you know, I guess if I prayed on it, I could, you know, overcome that and try to see things the way it should be. I'm dealing with DOC headquarters all the time, trying to get them to do things that I feel they're doing wrong. And, yeah, I guess I've got mixed feelings, I guess. Like I said, so negative, but I could be. I could
Okay.
change.
All right. And juror number 4, I just wanted to make sure you're not coming back until late in the afternoon on April 4, right? Or April 3, I'm sorry.
Yes, Your Honor.
Okay. Because at one point it sounded like you were getting in late on April 2nd, but that's not the case.
It's Monday. That's why I asked what day of the week
Right.
it was, because it's Monday afternoon.
And I think that's where I got confused thinking you were coming in on Sunday instead of Monday, but it is April 3, late in the afternoon that you're coming back.
Right.
Right. Okay. Okay. Um, all right. You've all been subject to a number to questioning by myself, by the attorneys. And the question that I have for you now is, if you are selected as a juror in this case, are you willing and able to accept the basic principles of criminal law and render a fair and impartial verdict based solely on the evidence presented at trial and the law as I give it to you in my instructions? Is there anyone who is not willing or able to do that? Raise your hand. No response. You've been asked a lot of questions by myself and the attorneys. Is whether a specific question has been asked or not. If you are, is there any doubt that you have in the mind or anything that you have in the back of your mind that you're saying, you know, they didn't ask me this specifically, but I think this is something that they would want to know before selecting this jury? Anybody have any of those issues? No response. All right. Let me ask, does anybody either know myself or a member of my staff? Mr. Hercom, who do you know? Sorry. Juror number 66. Thank you. Yes, sir.
Just as I'm hearing in front of you, being involved in the association. With the
Okay. Anything about that you think would cause you any difficulty serving as a juror in this case?
want to make sure that was out there.
Okay. All right. Anyone else? Juror 14. Yes, ma'am.
Mr. Warner, I don't know you personally, but I've been in your courtrooms for proceedings in the past.
Okay.
And I don't know.
Anything about that you think would cause you any difficulty serving as a juror if you were selected to serve as a juror in this case?
Well, it shouldn't, impact that.
Okay. Okay. All right. All right. All right. With that, what we're going to do is take about a 20-minute recess. Again, don't discuss case among yourselves. Don't discuss it with anyone else. When you come back, what will happen is I'm going to excuse some other people. And what I found is that it's easier to actually tell you who is going to be staying in the courtroom as opposed to who I'm going to be excusing at that point in time. So, but we will be left with some people who will be staying here, and I will be excusing other people. And for the people who are staying here, I'll give you further instructions and tell you what you can expect going forward. So all rise for the jury, please.
Type of engineering work do you do? IT. I'm like a systems engineer for US Space Com.
Your jacket?
Oh, yeah, it's fine. You know,
Just a little faster. A little bit more time here. Oh. Not the one that we thought we might be. Yeah. Well, that's true. Yeah, that's true. It's on, it's fine. All right, thank you. You may all be seated. Record should reflect the jury has left the courtroom. Ms. Stauch, would you like to take your break now, or are you okay? Okay, well, we would wait until you come back, so it's up to you. You want to do it now? Okay. So court will be in recess for about 10 minutes then. And then when we come back, we will talk about the jurors.
right now. So that is my concern.
Mr. Allen?
So he also said that NGRI is a valid defense. He's very open-minded, said he can be fair and impartial. And we have to take what is put onto these questionnaires, and this is going to be the response for probably a lot of these, in context of what they then voice when they get here into the courtroom. They don't know anything when they are filling out these questionnaires. They come in here and then they start to hear about the concepts and legal things that we will hold them to. And once he was explained those things, then he said that he could be very open-minded, said he can be fair and impartial, and also included that NGRI is valid. So I don't think that that's a valid cause to excuse him.
I agree. I think that juror number 2 has been rehabilitated sufficiently to allow him to serve on this jury. This is an issue that we ran into largely because you can't explain a lot to them about the law before they fill out the questionnaire. We're just trying to get certain opinions. And the opinion that I got from him was, well, I didn't know the law when I was filling that out. Now I understand it does make sense to me. The challenge for causes to juror number 2 is denied. As to challenge for cause as to juror 13.
Well,
Your Honor, other than 2, we have
I said challenge for cause as to juror 13.
13, yes.
You know, it's what's the position of the parties with respect to webinar as to this part of the process? The law is that challenges for cause should be made outside the presence of the jurors. It is because the jurors are in the hallway. So potentially, what's the position of the people?
I would just ask for consistency. I'm not sure if it's been broadcast the other 2 days or not.
I believe it has. It's not. Right. Okay. Defense? What's your position?
Public.
Yeah, it seems to me if somebody was here.
Why we don't let the
Right.
jurors here, because they don't want to hear why I think they're not fair, but I think.
I agree.
I think yesterday afternoon, Your Honor, you said, well, the jurors have to be out of here, but during this portion of
Yeah.
challenges for cause, somebody could walk out
Right.
in here from the public and sit in the courtroom.
Go
So I
ahead.
think we should probably
Yeah,
do it.
I agree. Turn it on.
We're on 13.
13. Mr. Cook, what was the reason for striking 13?
This is a questionnaire situation. Mine is made up from what I've seen on news media. That was question 21. 23 is seems to be hoping for lesser charge by plea of insanity. Did make some statements that it was gonna he was gonna have some of the issues due to the charges of nature. He also put length of trial would be an issue, would make difficult but not possible. With his questionnaire and what he said, I think he was very minimally rehabilitated by Mr. Allen. Still, I think, made clear indications, verbally and written, that
Mr. Allen?
Similar to number 2, he indicated that the information that he got was from the media. We had a discussion about the media, how they don't always get the facts correct. After we had discussed all day long today, he also indicated and said specifically that he can be fair and impartial once we gave him more information about these proceedings. So again, would object to that one.
I tend to agree with the prosecution here. The challenge for causes to juror 13 is denied. Next challenge was to juror 24.
issue. But she was the one that was pregnant and seen the photos. I talked to her at length about this. But, you know, I could maybe do it, try it. I think it was gonna be very awesome. Like a person that was really trained to, do her civic duty, and it was a huge issue for her. She really wanted to do it, but she just body language and whatnot. 5 weeks, or almost 5 months pregnant. This was gonna be a little raised her hand different times. Feels that this is the case. And also, she wrote on her questionnaire, she's out April 5th and April 4th. Your trial days, I don't know if there was any more, I don't recall any follow-up with that, but that's.
I did notice that too, and I was,
One juror who's not able to be one day at hearing, so this is somebody who's indicated two possible days.
Mr. Allen.
So there's I think gonna be a slew of folks that Mr. Cook is asking for cause because they said they don't want to look at the pictures. And I think juror 49, who we already, I think both have him on the list, said it the best. This evidence is gonna be hard for everybody to look at. I don't like looking at these autopsy pictures. And yet 24 and all of the others also said that they don't want to, but if they're asked to do it, they will do it. And she said that specifically. When we were talking about hardship earlier, she didn't specifically bring that up, although I'm not sure if I have the correct memory, that she said she could reschedule. Is that the one that said that?
Well, I have to admit, I'm a little foggy on that as well. So I would ask her when she comes back in so I can clarify, because I had the same issue with the gentleman, juror number 4 on the April 3. And so I would need to clarify that. But I remember when I looked at this over the lunch hour that I saw that she was gone those dates. And May 4 is a Thursday, so that's not an issue. And April 5th is a Wednesday, so we'll have to clarify that, but I can talk to her about that. So aside from those issues, did you have any other record to make with respect to juror 24?
No, Judge.
I saw juror 24's body language as well. I don't mean this in a flippant way. I really don't. But I have to tell you, if we had people in here that were saying, I can see these autopsy photos and they're not going to bother me a bit, everybody would be asking for that person to be excused. I just cannot believe that that is a normal reaction. I think the normal reaction, and we've all seen really horrific stuff in the job that we do. I think the natural reaction, much like, who was it? It was juror 40 in the back that said, I think I would have an emotional reaction. And I can't say that I won't. I think that's normal. But she said that she thought she would be able to set that aside. She thought that she would be able to follow the process. She thought that she would be able to be a fair and impartial juror in this case. And based on the way she was acting about it, her body language, I saw it differently than Mr. Cook. I don't know whether it's a different vantage point or not. But I think that she can. I am going to reserve the issue about conflict for April 5, so I will ask her about that, but otherwise the challenge is denied. Next juror is juror 34. Gentleman over here on the far end.
I'm concerned with what he put on his questionnaire. Question 21 of the questionnaire. Children. So with respect to insanity. So there had been some rehab done by Mr. Allen. I don't think he ever discussed the insanity. Position on what he said about it. But the thing. And it's clearly
Mr. Allen?
Similar to what I've said in the others, I think if I remember correctly, in the morning session, he stood up after one of the other jurors had clarified his statements about some of the things he had put in his questionnaire, said, now that I've heard more stuff, I think I can be fair and impartial. I talked to him about those things as well, and he indicated that again. And then as it relates directly to insanity, I asked him about that, and he said he can be objective on that very point.
I recall this juror because I had a really long discussion with him about how the purpose of criminal law is behavior modification, and that a mental state has to be proven with respect to that, and why it's important for that to occur. And I believe that he understood the law. I believe that he conveyed that he could be fair and impartial in this case. The challenge as to juror number 34 is denied. Next challenge is to juror number 36.
Yes, Your Honor. This was, juror number 30.
This was the woman who had a stillborn child.
Stillborn child, and we talked to her several times. She was like, yeah, I'd like to say I could soldier through it, like, they do with the military. But she got emotional and talked about, I still remember holding this kid as this child is resulting in death. And murder of a child. So I think she was trying to put her best face forward, but I think at the end she has some personal issues that are very difficult for her.
Mr. Allen? Oh, sorry.
And beyond that, she mentioned it several times about the stillborn child. She also did in her questionnaire say, I don't see that is a valid reason for a person that she didn't check. Insanity question in the questionnaire. So, but yeah.
Okay.
My big concern is, I think everybody wants to do their duty. And I think near the end, she finally came forward with her, most, reliable statements that, yeah, I don't want to do this and I can't do it. It's just too much. And her body language, her speaking clearly did indicate that this was being for her. Not just the typical run of the mill, hey, we're all gonna have problems seeing photos. Child, I get that. This was something.
Mr. Allen?
Similar to what I've said in the past on the other jurors on this particular issue, that yes, it's going to be very difficult for her, but she indicated that if she's asked to do it, that she could do it. I don't remember specifically statements that she made as it relates to question number 23 on the questionnaire, but I do remember specifically talking with her about being fair and impartial, and she indicated that she could be.
For me, I think what sways me a little bit more is, as I understood the facts and the way that she relayed the details, this was an incident that occurred probably 17 years ago. I think she said something along the lines, it stays with you, it never goes away. I can understand that. And for her, it is something that came right to mind almost immediately. That was something that I remember her mentioning it early on, and she has mentioned it more than once. And when we talk about different aspects of the case, including just the fact of an 11-year-old child who is dead, and we talk about the autopsy photos and stuff like that, she keeps referring back to, you know, I had the stillborn child, I had this life. And so for her, I just think that it is too big of a hurdle to get over. So I will grant the challenge for cause as to juror 36. As to juror 37.
Judge, juror 37, I believe she was teacher
Yes.
at the special needs, but lower income, lower areas, and she originally didn't discuss the issue with, she might photos and everything. And then my colleagues on the other side were making fun of me when I was talking about their vacation plans on March 7th. However, the bigger issue is that she indicated that she might be thinking kids that are not all the way normal kids. I think it was for more than other kids, and they want to why they feel that abandonment issues, it would be really hard. That juror was released, especially this teacher. I hope this is the same situation with this. And if you know, Your Honor, yeah, she could probably recommend anybody in this building that is using humans are pretty fair a lot, doesn't mean. It's the sub doing okay, you know, I don't know, I'm not a teacher, but I imagine those are thoughts that go on, so. That would be my basis for 37.
All right. Mr. Allen?
Judge, I don't think any of the reasons that we just heard are good grounds to excuse her for cause. She did worry about missing work for an extended period of time, but that's going to be an inconvenience for anybody that we sit in this on this jury, so I would object.
Yeah, I tend to agree. I think she's in a little bit different position than the juror that we excused this morning. That juror, the first thing that juror described was the special needs and how it was that they were that teacher was sort of the connection to the outside world. This juror is in a little bit different position. And she didn't talk in those terms about how this would affect others. In addition, to an extent that it may affect others, that's not necessarily a reason for excusing a juror. So the challenge to juror 37 is denied. Next challenge juror was 39.
39, she was one of the individuals that in the very, very negative beyond what a normal person would experience. Negative reaction, emotion. This is a good. Social media. There she is.
Mr. Allen?
Again, the pictures issue is going to be difficult for everybody. We apply to this juror as well, and that's not a ground for pause. As it relates to her questionnaire, she does say that she followed the case, but then she goes on in question 21 to say that, yes, she can be fair and impartial. And then in question 23, to the NJRI, she says, I would need to hear the evidence for her plea. So basically she's indicating, yes, she's going to sit and listen to the evidence and not what she heard in the media, and I would object.
I agree. I don't think there's been sufficient grounds given for excusal of juror 39 for cause. The juror said that she would need to wait and see what the evidence is. And as I've said before, I think that everybody is going to have a negative reaction to the photographs. And I think someone who didn't, that actually might be a reason for excusal, depending on the circumstances. But the challenge for cause as to juror 39 is denied. As to juror 51,
Section 23, Your Honor, of the questionnaire, I do not believe.
this is juror 51.
This is 51.
Okay, go ahead.
Under court, question 23 in the jury questionnaire. I
Okay.
do not believe in the state of insanity. There
Oh.
is no reason to keep someone alive. Perfect symptom, and then say, well, they are insane. A plea of insanity does not bring the person back to the dead.
I recalled reading that over the lunch, Mr. Allen.
I think that is problematic. I would only point to 21, saying that he just wants the facts and the truth. So indicating that he could potentially be fair and impartial, although that statement is pretty strong.
Well, I remembered reading that. My initial reaction was that juror 51 needs to be excused. So the challenge for causes to juror 51 is granted. Challenge for causes to juror 53.
53, Your Honor, I don't know if anybody's talked to her. In her questionnaire, you put under 23, this is a person that it's a lot of information about what she had heard about Gannon before. 23, the insanity question says, where's that an excuse to try to get out of insanity? 21 is, while I do find Letecia's involvement highly suspicious, evidence of her guilt beyond reason. So I get the whole we must prove beyond a reasonable doubt. You know, right now, starting point, she's putting, you know, she's not innocent. Presume innocent, the other. He heard highly suspicious. Feels like she also did put 25, while not impossible, it would be very difficult if they went billed with only $60 compensation. So it looks like she's a retail manager and probably has some income issues. She was a person, so like, I didn't talk to her, and I don't believe Mr. Allen ever. That being said, this is the situation. Academics, open statements, you know, that the.
Mr. Allen?
She was quiet. I don't remember her saying a single thing the whole day. She clearly knows some stuff about the case, but then she goes on in 21 to say, yes, she can be fair and impartial. And in fact, I think this is a really good statement. While I do find her involvement highly suspicious, evidence must prove her guilt beyond reasonable doubt. That shows a very good understanding of the law. She does have the indication in 23 to yes, but then in 24, when it's asked to expand on that, can you set aside that opinion and render a fair and impartial verdict based on the evidence presented at trial? And she says yes. And so I would object, saying that that's not a reasonable grounds for cause.
Yeah, I don't think there's anything, frankly, in the questionnaire that concerns me aside from perhaps the hardship. And when I asked questions regarding hardship, she didn't respond at all about anything. I will deny that challenge for cause at this point in time. Juror 73.
72, Your Honor. This was a questionnaire issue, probably not, you know, under questionnaire 21. Heard, read, or discussed anything with partial. But probably not, based on the state of the charges. And then he also mentioned that the school problems, hearing loss, difficult, to difficult in large groups, 2 bladder problems due to surgery, radiation treatment, state cancer, frequent trips to the restroom. So I don't think that was followed up on the couple hardships that he went. And very quickly, I think he was the gentleman that just got. That the one you're on?
No, the one that said that was. Oh, it
It
was.
was him, Judge.
It was him. Yeah, it was him. Yes.
You know, he did pipe up and say he changed his mind. But he wasn't very specific about what he changed his mind about. But now that I've heard some of the stuff about. Alan, I don't believe followed up with him. I didn't have time to follow statements that probably cannot. Are impartial based on the state of charges and specifically. Had an unfair hardship.
All right, Mr. Allen?
He was very apologetic, actually, and I think showed reflection of the gravity of what all of these potential jurors are being asked to do, which is to sit on a really high-profile, horrific case and hear evidence. And again, when he filled out the questionnaire, I don't think he understood that based on what he said to you, that he volunteered. It wasn't even to any question. He just stood up and brought it to your attention. I also want to make sure that the record is clear that this is the juror that I know from political circles. And I asked him about that as well, and he said that he could be fair and impartial, even though he knows me through that arena. I think everything that he has said modifies his written statement and is not a good grounds for cause.
All right. All right, I am going to deny the challenge for cause as to juror number 73. I recall when he did that and he said, you know, now that you've explained all of this, he said, I wanted to change some of the answers that I had to my questionnaire. So I will deny that.
There's one other one,
Okay.
58, I wanted to bring up as well.
58. Okay.
I don't believe anybody talked to this individual. But this individual indicated under the questionnaire they are unavailable Monday, Wednesday, Friday, and Tuesday. And then number 25, the reason the time necessary. Anyway, section 25. Yeah, I can't do that.
Take a look at that.
Hormone shots every Wednesday. So nobody talked to this person.
Okay. And he didn't raise anything about it. So I'll ask that.
Okay.
Judge, as it relates to, well, yeah, I think that's just something to follow up with.
Yeah, right, because he didn't say anything about it when I asked about hardship or anything like that. And as to juror number 14, no, I'm gonna deny the challenge. I think that I understand that she has some distrust of the system. I don't think that that necessarily disqualifies somebody. Don't get me wrong. I don't think that, I'm not saying you can't use a peremptory challenge on her, but I don't think that that necessarily disqualifies someone. I do still think that people who have a distrust of the system, I think they make good jurors. So I'm going to deny the challenge to juror 14. Did you want to make further record, Mr. Tellini?
No, I was just gonna say, I think it's a different saying I discussed the system. She didn't say anything specifically about the prosecution that she.
Right.
had a bias against them or anything like that. And so I think it's a difference, but I think there's something wrong with the
Right.
system versus I think that the DA is working.
Well, and that's where I'm resting it on. And I also, I've seen those cases where I had one not too long ago where a potential juror said, I'm not going to believe anything that any cop ever tells me at any point in time. They're all dishonest. I mean, I didn't get that. I got that she had and has had perhaps a poor experience with the judicial system, but yeah, I'll just leave it at that.
Judge, can I just make a quick record
Go
about
ahead.
that particular juror?
14, yeah, go
Yeah,
ahead.
14. I think it's pretty clear, if we get to the point that we use a peremptory on 14, the reasons why that might be. And I just want to make sure that we're all clear on the record that, if it comes to that those will be the reasons. Obviously, she is, Hispanic and, want to head off any Batson challenges.
I see where you're at. Yeah, that's fine. Okay, let's go ahead and bring the jurors in. Oh. Council approach for a minute, please. So I got it.
And the camera wants to.
6:50.
He said he does.
Okay, I wanted to follow up with a couple of things. Juror 24, we were looking at your questionnaire and you said that you were not available on April 5 and May 4. Why is that?
I have scheduled, like,
Okay, and the May 4 one is not a big issue because that's a Thursday. The April 5 would be a Wednesday, the week that we start trial. Would you be able to reschedule that?
it's possible. I absolutely have no idea.
Okay, I want you to check between now and April 3. Okay, because when you come back on April 3, you'll be one of the ones coming back on April 3, and that's going to be one of the questions I ask. Okay? Juror 58 in the gentleman in the black cover here. You said that you were unavailable on Monday, Tuesday, Wednesday, and Friday. Is that every week? And why is that? Okay. Everybody's working. Okay, what kind of work do you do? Okay. I want you to check as well, because I have had jurors in the past that Walmart did pay for jury service. So you'll be coming back on April 3 as well. So between now and then, I want you to ask your supervisors at Walmart whether or not they will continue to pay you for jury service, okay? Okay? Okay. All right. Here's what we're going to do. I'm going to point out who the jurors are that we're going to be having come back on April 3. And before anybody else is excused, you're going to see me confirm that with the attorneys to make sure that we all have the same people and the same numbers. And then if you are confirmed, remain in your seat. If you're not confirmed, you can leave because your service here is done, and you can go on about your business. So. Here, back one down. Figure this out. Right, so we need, remember 22, return. For 13. 17. 17.
That's the party cue, Judge.
No, he's closed his eyes. 19, you'll need to return as well. Return on April 3. 21. 24. 29. 33. 34. Here. 35. 37. 38. 39. 40. 43. 47. 53, 53 right here. 58. 73 and 74. Those are the people that I need to return on April 3. Agree?
Yes.
Agree. All right. So the people that I said need to stay here, stay here. Everybody else is free to leave with the case.
Okay.
Okay. All right. So here's what you can expect going forward. The attorneys and I are going to continue to be in jury selection mode for about the next week. And then we will have all of you return on Monday, April 3 at 9 a.m. In a moment, Mr. Combs and Mr. Sproul are going to give you a card that will have your return time here. It also has contact information for us. So if something happens, some emergency happens between now and then, you will have contact information on how to get a hold of us and tell us what that is. Otherwise, be here on April 3. We're going to get some contact information from you. We need a phone number, an email, and then if something comes up, we can let you know. We anticipate that going through jury selection, what will occur is that by Monday, April 3, we will have 110 qualified jurors that have gone through this same scenario that you have gone through. We will have 75 of those report at 9 a.m. because we can only fit 75 in here. Then the attorneys will exercise their peremptory challenges. Those are challenges that they can exercise for any basis or no basis whatsoever. Essentially, they just can't use an illegal basis or something of that nature. So they can excuse you, and then ultimately we will end up with with 18 jurors, 12 of whom will comprise the panel. We'll have 6 alternates. We always choose alternates because the case is going so long. So in this case, that's what we've done is 1 alternate for each anticipated week of trial. So you're not yet on this jury, but anticipate that you will be. And that's important because, let me read this, read you part of this instruction. You have probably already guessed that there has been some public or media interest in this case. There could be more in the coming weeks. You must guard against that, as you will be required to decide this case based on the evidence presented and the instructions I give to you. You can tell your friends and family you may be on this jury and how long you think it will go. You can ask for their help in avoiding exposure to stories or even opinions from others regarding this case, but you cannot otherwise discuss anything about this case with anyone. and you should not listen to any opinions regarding this case from anyone else. If someone asks you why, just tell them it's because I told you so. That puts the burden on me and not on you. You may still blog or communicate, just not about this case. You cannot do any blogging about your jury experience or communication with other jurors. You can still watch TV. You can still go on the internet. You can still do your shopping on Amazon. You can do all of those things, but you cannot do anything that has to do with this case. If you see a television news story or any other story come up about this case, turn the channel, turn the TV off. If you see something on the internet, just go to the next page, swipe right or left or whatever it is. You are not allowed to look at, read, consult, or use any material of any kind, including any newspapers, magazines, television and radio broadcasts, dictionaries, medical, scientific, technical, religious, or law books or materials, or the internet in connection with your jury service. I want to emphasize that you must not seek or receive any information about this case from the internet, which includes all social networking, Google, Wikipedia, blogs, and any other website. You're not allowed to do any research of any kind about this case or this kind of case. Once this case is done, you can do all of that. You can talk to anybody you want. You can tell them anything that you want. You can tell them as little as you want or as much as you want, but you simply cannot do that while this case is pending. So when we come back on April 3, what will occur is we'll bring you all in here. I will ask you some brief questions because sometimes circumstances change. And I wanted to talk to Juror 58. Make sure you talk with your employer, see if they will compensate you. Juror 43, I want you to do the same thing. I have a vague recollection, and it's really vague, so I don't know how accurate it is, that I had somebody from a car dealership before that was here that they continued to pay while on jury service, but I'm not certain. So I want you to check with your employer, okay? If they need something from me to say, yeah, right, you're going on a vacation for 6 weeks, right? If they need something from me, you will have the contact information. Contact us, let us know, and we will get something to you, okay? So, because when you come back, one of the first things that I'm going to ask, especially of you two, is, did you check? What did you find out? Okay, so make sure that you do that. With that, I'm going to have Mr. Sproul and Mr. Combs give you give you a list so that we can get some information from you.
And that's that on that today. There we go with that one. That's that on that today. I can hear myself. What? Oh, because I'm playing my phone. Whatever. Sorry. I've got to go deal with my son. He's having some stomach problems. I'll see you guys around. And it'll be playing on here again tomorrow.